Lordship, I'm mentioning for leave to file an application for addition of parties without
For that,
but short, my lord. Actually, my lord, I have not getting any proper cost title balance. I want to make a mentioning for file an application with a short cost title, your lordship.
you have a right to go for an inspection. You can do it. There is no difficulty. Why?
My lord, this
You
is
can go for an
I'm not a
inspection.
party in that application, my lord, but I am just a for addition
Maybe
of party.
for addition of party, what is required? Leave is required for the court. I never heard of. This is a new thing I'm learning.
Since I have been suggesting.
Sir, there are ways and means. No.
My lord, may I have your lordship's leave to mention a matter for non-prosecution, my lord? It's a
Oh,
commercial
always
division
welcome.
matter.
Give.
Parties have settled the issues by way of settlement.
Whatever, give.
May I permit to mention, my lord, physical filing for due to, my lord, server problem, my lord, I am appearing on behalf of the state, my lord, appeal filed with, my lord, physical filing, my lord, for physical filing, my lord. Due to server problem, my lord.
You have a certified copy with you?
Yes, original certified copy.
File a physical one.
No, my lord, state is not, state is mandatory, my lord, without leave.
Okay.
Milord, may I have a kind leave to mention one matter, Milord? This is, Milord, pertaining to that matter Mr. Mukherjee argued on Non-Agricultural Tenancy Act and Estate Acquisition Act on that proposition. Milord,
We are in the midst of dictating.
no,
Don't
Milord,
worry.
just one thing, Milord. We have prepared a list of judgments, Milord.
Sorry,
that would
we
like
have
to rely
already
on.
started dictating. We have done judgment is already complete.
Lordship,
Sorry.
praying for lordship's indulgence, your lordship. Lordship, I'm praying for lordship indulgence, your lordship, in this matter, my lord. Without advocate and record of the parties, no one can. I'm the outsider, my lord. I cannot make an inspection of the record, my lord.
There are ways and means you can do it.
Fine.
I used to do when I was an advocate and record on that side.
Fine.
Well, the peculiar situation.
I'm
opposing this, my lord.
কালকে তো তুমি এটা পাঠাওনি সেই জন্য বললাম কালকে আমি পড়িনি আমি সব পড়ে এসেছিলাম যেটা পাঠিয়েছো তো এটা নিউ তো এটা নিউ তো এটাও নিউ এটা কি সম্ভব যে আমি 1-2 সপ্তাহ আগে পড়েছি আমার সব মনে থাকবে not expected just give us 1 minute
No, I was only.
Well, may I just take a minute to tell you, lordship?
just 1 minute just one give us Oh, this is that matter where ultimately the award is passed more than the.
Not
Sorry. CIRP proceeding has been admitted. Resolution professional has admitted the claim
for more than
the award amount.
Right.
Now, what is to be done?
That's right. Well, this matter will have to be heard.
Now
It's an interesting point.
Now I recollect.
In fact, my lord, it was taken up by your lordships, my lord. On
Now, what is to be done?
This matter is interesting.
We were a bit, skeptical about it. What to do?
But what
is the effect of the admission of the claim?
There is no admission of the claim. I shall show you.
This is what it's.
I shall show you, lordships.
Well,
they have accepted, my lord, the resolution plan. They did not challenge the resolution plan. After that, my lord, in any event, my lord,
But ultimately, if the claim is admitted,
and my lord, the law says, my lord, whatever the resolution plan would say, that would be payable.
My lord, may I just, my lord, put it in perspective? My lord,
I'm sorry. And my lord, question of, my lord, maintainability of the appeal is definitely there.
My lord, lordship will kindly, my lord, have a look at, my lord, paragraph 7. This is, my lord, what troubles me immediately. Paragraph 7 of the impugned order.
The impugned order ends at page 5.
Yes, but it ends at paragraph 8. Paragraph 7 is, my lord, what is immediately, my lord, troubling me. Prayer H of the tabular statement is attachment of my bank accounts. I'm the KMDA.
What is this? H, prayer H.
My lord, that
Nowadays,
is,
if I correctly remember when I joined, in all these matters where the orders are passed in terms of
set out
prayer,
the prayers.
they were set out at the bottom.
Yes.
But nowadays that system has gone. If I correctly
Yes,
remember,
yes.
that used to be like that. What is happening in the original side, I do not know. The minutes are never prepared. Minutes are the reproduction of the last portion of the order, which was never the.
When I joined, in fact, my lord, possibly all three of us joined. There
No, you joined earlier than
No.
earlier to all of us.
Definitely.
Yes.
I cannot, my lord, say. Now, even my lord, quite a few years thereafter, after I joined, there used to be a minute book where, my lord, the entire order used to be recorded.
Not entire order. Actually, what happened during the proceeding, those used to be,
And the order.
and then the operative portion of the order. Entire order. I have come across with those minutes where what has been said, what has not been said, everything was
Judgment.
recorded.
Unless it is a judgment, my lord, the entire order.
Yes. But nowadays, nobody.
My lord, there's an order of attachment, my lord, that's directed. My lord, this is an interesting point. My lord, your lordships will have to, my lord,
No,
consider this.
I said that on that day.
I was only, my lord, humbly praying that kindly take it up after the vacation. In the meantime, let them not, my lord, proceed to attach the account. My lord,
It's not
KMDA
an
is-
order of attachment. May I read it out?
What is this prayer H?
Yes, may I read it out? An order of injunction be passed restraining the judgment debtor from dealing with and or disposing of and or alienating and or transferring and or parting with possession of any assets or property of the judgment debtor, and particularly those mentioned in paragraph 7 hereof, or from operating the bank account.
This is what is also there.
And particularly those mentioned in paragraph 8 without leaving apart a sum of rupees such and such. Now I shall show your lordships, they agreed to this.
No, I had, my
Now
lord,
they
but that
cannot
is
turn
before. No, my lord, that is before, my lord, I was communicated that, my lord, my claim has been accepted. My lord, award is made, I have challenged the award. Section 34 challenge is pending. Section 36, my lord, I have to ask for stay. My lord, at the time of stay, my lord, I have to make a deposit, I agreed. But, my lord, then, my lord, I was communicated the fact that, my lord, the RP has, my lord, accept my claim in its entirety, which is, my lord, in excess of the, my lord, arbitral award against me.
And what is the resolution plan?
Well, a resolution plan, my lord, accepts my claim and says in terms of the waterfall mechanism or, my lord, the haircut mechanism, you'll get 4 lakhs of rupees out of 80 lakhs of rupees that is due to you.
4 lakhs
80
only.
crores. Out of 80 crores, you'll get 4 lakhs.
Only.
Yes.
Not challenged.
No, no.
Provision of appeal is there.
No, my
Not
lord.
challenged.
No, my lord, with the greatest respect.
Provision of
My
appeal.
lord, I have no right to, my lord, challenge, my lord, this in the resolution plan. I have no locus. I am a creditor. I have no locus, my lord, to step in and, my lord, question the, my lord, commercial wisdom of the committee of creditors in accepting a resolution plan under which, my lord, my haircut, well, amounts to 4 lakhs out of 80 crores.
May I read out, my lord, the order?
Well, may I
Passed
only
in
say this?
36. May I?
My lord,
Kindly come to first volume, my lord.
well,
page 102.
I did agree.
Page
I am not,
102.
I'm not disputing that I had, my lord, agreed to, my lord, make this deposit. But, my lord, the question is, my
Fourth
lord, after
paragraph
that,
of Page 102.
my lord, this is an event that intervenes.
Nothing has intervened which can, my lord, modify the order. Page 102, fourth paragraph. The learned counsel appearing on behalf of the award debtor submits that his client is willing to put in the said
No,
sum.
where it is?
Volume 1, my,
Impugned order.
No, impugned order is not there.
not the impugned order. Not the impugned order. My lord.
Page.
The order passed in, my lord,
Page.
36 to application. Page 101, the order starts.
101.
Yes. Kindly take note of the date. 13th December 2022.
And what is challenged here?
My lord, here, my lord, what is challenged? I had made an application
April 25, 2023.
for, my lord, modification of this order to relieve me of the obligation of making the deposit, consequent on, my lord, the disclosure of the fact that my claim has been admitted for a much larger amount.
But now you say resolution plan says only
No, no.
4 lakhs.
My lord, kindly see, my lord, what is the resolution plan? my lord, may I just, my lord, take 1 minute of your lordship's time? My lord, when I make a claim and there's a counter claim, my lord, then, my lord, for the counter claim to operate and for there to be an equitable setup under Order 8, Rule 6 of the Civil Procedure Code, it must arise out of the same transaction between the same parties.
I understand. So far as a set off is concerned, you can definitely take
Now-
that plea. But now the problem is because the resolution.
No,
plan-
my lord, kindly allow me just 1 minute. My lord, it's an interesting question. Now, my lord, today, normally when there's a claim and a counter claim, my lord, as a result of which one claim is set off against the other, then, my lord, the final value of the claim is determined on, my lord, the set off.
True.
Now, my lord, let us assume for the sake of argument that, my lord, I get 100 rupees from Mr. Mitro's client.
No, I
Mr.
understand. And
So, my lord, the question is, my lord, let us say Mr. Mitro's client gets, my lord, 110 rupees.
then
and
for
there's an
10
award.
rupees he is
He
liable
will
to
then
get set
be
off.
entitled to only 10 rupees.
That's true.
Now,
That
my lord,
is-
here, he says I'm entitled to 60 crores,
I know. You say 80 crores, 80 lakhs.
80
that is
crores.
80 crores. And that has been admitted.
That has been admitted in its entirety. So therefore, the question is, what is Mr. Mitro's claim? I'm not, my lord, concerned about my claim at the moment.
Whatever is there, 60.
That's right.
64
Well, if
lakhs.
today I get 4 lakhs, I get 4 lakhs. But, my lord, the question is, can Mr. Mitro's claim then stand at 69 crores?
Always. 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 It should.
Well, the question is,
Should.
that is.
That's my opinion. It should.
No, my lord, your lordship,
Because
certainly.
after all, it is a decree.
No, my lord, with the greatest respect.
Kindly
No,
visualize.
okay, kindly see. No,
I'm telling you. Please let me understand. Had there been a decree and a counter decree, I could have understood.
but I was not allowed by the operation of law to proceed to a decree.
Now
And the
the-
Supreme Court has said that, my lord, because of the moratorium provisions, I cannot, my lord, proceed in arbitration, but I have to file my claim before the RP. RP, my lord, if he does not, my lord, admit or does admit my claim, and, my lord, my learned friend is not happy with, my lord, the admission of claim, he has a provision for appeal.
No, I understand. Suppose what is the effect of those? Suppose a resolution professionals admitted the claim. Does it become immediately payable by the company like that, or it is recoverable
No.
through
Well,
any
there is
other
a
modes?
distinction. My lord, may I just say, my lord, kindly do not, my lord, there are previous judgments and, my lord, there are subsequent judgments. I shall place those judgments. But, my lord, the net effect is, my lord, if today I am, my lord, pursuing a claim before one court, but by, my lord, operational statute, my lord, I am precluded. My lord, the question is, my lord, in the course of determining my learned friend's claim, what would be the total amount payable to him? I'm not, my lord, asking for payment to me. Payable to him. We are talking about
Then
determination
under-
of, my lord, the
under
claimant's claim.
Under Order 21, Rule 1, let us understand that how far that can be done. If you come, if you come, Rule 1. First thing is by deposit into the court whose duty it is to execute the decree or send it to the court or a bank first. Then out of court to the decree holder by postal money order, and then third. Otherwise, the court which made the decree directs. Then 3, where any payment is made under clause A or C of rule, the judgment debtor shall give a notice of the decree holder, where a money is paid by this. And then these are the modes where it says that this can be done. There is no other
I am, my
mode.
lord, I
There
am
is
not,
no
my
other
lord,
mode
I am
which
not
is
even
provided.
going there. My lord, I am not for once, my lord, saying, my lord, the question is, my lord, today, my lord, I have applied for setting aside. My lord, the law says, my lord, it is not final till the setting aside is decided. So, my lord, it has not yet matured into, my lord, a decree per se, not an executable decree, because, my lord, section
Now,
36
Rule 2.
intervenes.
Rule 2.
Yes, rule 2, my lord.
Now, the question is where any amount payable under a decree of any kind is paid out of court, or that is a very important.
Yes,
Or the decree of any kind is otherwise adjusted
that's right.
in whole
No,
or
my
in
lord,
part.
this is out of court. My lord, this talks about, my lord, a settlement between the parties.
No. The disjunctive word is there. The disjunctive word is there. First thing is a paid out of court or adjusted.
Shankar, so definitely.
My lord, may I do this? My lord, your lordship will have to, my lord, consider this question. My lord, kindly, my lord, keep it after the vacation. I can only suggest this. My lord, so far as my lord 8 crores is concerned, I shall keep it in my bank account, my lord, at all times to come.
That is what an injunction is.
No, my lord, I will not, my lord, I
That
do
is
not,
what an injunction is.
may I kindly make that clear, my lord, then, my lord, I will not, my lord.
No, no, he has read out that you can't deal with the assets of the company for any time, or nor you will operate the bank account beyond this amount. Within that amount.
Without
You
keeping
can
this
use it beyond that. So there is no difficulty. That's the order. I think you read out H.
Yes, yes. I read it.
Oh, my lord, I'm told that, my lord, there is difficulty of the KMD in this regard. My lord, in that case, my
Because
lord,
if the amount goes down or below this amount, then you can't operate. Up to the extent of 69 lakh crores.
my lord, kindly
I am
keep it,
more
kindly keep it on
lakhs,
the reopening, my
I
lord,
don't
let me
have-
also take instructions. My lord, kindly keep it on the reopening, let me take instructions. KMD is not running away anywhere. My lord, this is, my lord,
I do not,
What?
I do not know whether KMDA is running away or my lord KMDA is capable of paying the money, because my lord this stand taken earlier was yes, yes, we shall deposit the entire money. Now the stand is KMDA is unable to
my lord,
deposit.
KMD had taken out an application saying that, my lord, it is in difficulty
And I show your
circumstances.
lordships how frivolous the stand of KMDA was. I was showing your lordship.
I am only on a question of law.
May
I am, my lord, now on a question of law.
I did not interrupt my learned friend. And I expect that also from him. The order passed in 36-2, they said, I showed that we shall deposit the entire amount. 8 weeks time was given. On the last day, they came up with an application. No, we do not want to deposit. We want to give by some other property. When I opposed that, they withdrew that and now came up with this application. My lord, your lordships are aware, my lord, this money, my lord, the law says that if the money is deposited, I am entitled to withdraw it.
No,
By
that is
giving
why
security.
I showed you order 21 rule 1.
Yes.
That is a duty that they have
Absolutely.
to. That's why I invited his attention to that.
And my lord,
My lord, this is a
because of
special, my lord,
KMT,
code
my lord, I would be destroyed.
that creates inequities between the parties. I mean, it has to be viewed, my lord, with a special, my lord, from a special perspective.
That is what is there. Clause C.
Your lordship will
Otherwise, the court directs. Under order 21 rule 1, clause C,
Well,
the court's
kindly-
power is also
my
there.
lord, I rush.
Otherwise, the court
Kindly,
directs.
kindly take it up after the vacation. My lord, I am in some difficulty today, my lord. I have to leave.
Do it today.
Well, no, it's not that. I'm at the arbitration. It's the international arbitration center.
Where?
Virtually, my lord. At 11 o'clock, my lord, my lord.
And he has to catch a flight.
No, that is in the
Immediately
that
thereafter.
is in the afternoon. That is in the
Immediately
afternoon.
thereafter, that is why no, do it today.
Others, I would, my lord, say yes, but not Mr. Mitra. My lord. He will never, my lord, put me
Let
into
this
that.
matter be listed immediately after the reopening of
I'm
the following summer vacation.
grateful.
But an interesting
And my lord,
point, but I do not.
question of maintainability.
That is always there in the first order. First order, show it to him.
Should be. Sorry, man.
Well, this question has troubled the Delhi High Court, and well, there are 2-3 judgments. Then well, the Supreme Court has also considered this, and well, has equally been troubled by it. Well, there is one view of the Supreme Court which is affirmed by a later view of the Supreme Court, but does not directly address this issue.
Let us see.
Affidavit service.
Following summer vacation. But interesting point, I must say.
I appear for your penalties. And I'm led by Mr. Ratnakar Banerjee. May I be? I'm just praying for a short Passover, my lord.
May it be
Min-
taken up after vacation.
No, my lord, there is some urgency, my lord.
No urgency, my lord. Disclosure of certain documents
May I
refused by
indicate,
the
my lord,
trial.
if I may move my application.
Refusal.
This is
The only point is that.
By the impugned order, my lord, my
Only point is the amendment which has been brought under order 11, rule 1, sub rule 5. Whether any document subsequent to the filing of the pleading can be permitted. That's the only point.
Yes.
Let us hear
Yes, ma'am.
After vacation, after vacation,
Passover, he says
Yes.
Passover.
kindly takes it up tomorrow then at least.
My lord, I'm not there tomorrow, my lord.
No tomorrow business.
Or
I am
tomorrow-
also not there.
Tomorrow's the last day.
Don't
Yes.
worry, I am also not there.
I'm grateful. my lord.
It's sometime, my lord, I was.
Just a short
praying.
Passover, my lord.
Yes.
Very well.
Great.
Very good. My appeal, my lord. The last occasion, my lord, the matter came up, my lord, with
That subsequent atmosphere of the statement of parameters to the prior to filing of the bid. It's not subsequent. Our question is, once you have ordered disclose, statement of charter is declared. After, why the post is such? Why the post is such? Even if you the law, I do not find trouble. It is not- that it's not- that it is the- Sticky problem. No problem. Problem আছে।
Lord,
Erstwhile advocate.
Lord, we had issued a notice to him, my lord.
Lordship, on behalf of the respondent, I'm praying for a short Passover, Your Lordship.
My lord, this is what he had to say via
Hey,
electronic. mail.
Passover immediately our call kore now because there is no other matter. This is the only matter.
Yes, my lord, absolutely, my lord.
So you want a Passover, then Passover immediately it will be called.
Lordship, 5 minutes would be enough, Your Lordship.
It's my condemnation delay,
Where is
My lord,
where is the
I had issued notice to him, my lord, he has given a reply, my lord, kindly, my lord, takes. Nothing more to say, my lord.
Yeah, no,
Thank you. Could you please?
Yeah.
My lord, on the last occasion, my lord.
হয়ে গেছে রেডি সব বলা
অ্যাডভোকেট করে রাখতে বলেছেন।
Mark the lines which he says that all the we can touch up for a bullet correct for this. এই মিনিটে যেটা আছে
where is your client?
My lord, there are some things, my lord, it's little bit, my lord, on the murkier side.
After reading
the-
this,
Two things, my lord.
Mr. Mullik,
Yes, my lord.
after reading this,
Yes, my lord. Now, my lord, kindly, my lord. Two things, my lord. Two things.
where is your client?
Two things, my lord.
Where is your client?
My lord, he's at his home, my or office, my lord. I don't know, my lord. My lord, two things, my lord. My statements in the condemnation application
Are not
are not untrue. Kindly seize that. It's not untrue. Kindly seize that, my lord. Whatever he has said in the reply, in the letter,
He has robbed you. He has robbed
I
you.
am not there. I was not there. So, my lord, I don't know. I have also
Then-
have to
then-
have
then
a.
will you say that this is wrong?
My lord, I was never there.
Sorry.
I was
He
never
has
actually there.
indicated your name also.
Yes, I know that. Well, I've seen that. That's the
Yes,
reason more.
Then,
That is the more reason
then-
not there.
no, no. Is he a practitioner of this court? No,
Yes, my lord.
obviously.
Yes, my lord. He
He has
does.
an office here.
Yes, my lord. He has.
Can you contact him to come here immediately?
My lord, may I go outside and call him?
Call him to come.
একটা মেলের কপি দাও।
Call Ritobarato Mitro also.
I remember in few days back, a similar matter happened before court number 37, my lord. Lordship has called the lawyer from Alipur and he said that he has not given it, my lord.
I have a strongest of reservations when any allegations against the erstwhile advocate is made. And if we allow this application, that means impliedly we are accepting all those allegations to be true. Madam, you have to be very careful when you draft.
My lord, if I may, please.
If that is truth, then at least that lawyer must be notified
Yes.
and he must stand by his by these allegations, or he must refute
Fine.
the allegations.
Fine.
That's my strong view.
I bow down. My lord,
This
with the
can't be,
humblest,
this
may I
can't
make
be.
one humble submission, my lord. The section 5 application, my lord, firstly, makes no allegations against the
No,
previous
then
advocate.
how we directed?
My lord, if I may place, if my lord sees my lord's last order,
Correct.
my lord has specifically referred to paragraph 5 of
Five.
the petition.
Yes.
My lord, before that, may I also place paragraph 3 of the condonation? There arose certain differences of opinion between your petitioner and the erstwhile advocate on record. My lord, is it apparent from Mr. Das's email that that is absolutely correct? Therefore, my lord, no allegation as to his conduct, due to which your petitioner decided to change his advocate on record. However, the Honorable Court was closed from such and such to such and such. Normal functioning resumed on such and such, during which time your petitioner could not engage another advocate on record. My lord, I place paragraph 4.
Then
My lord, I am coming. Your petitioner received the no objection from the erstwhile advocate on record on or about January 19, 2023. My lord, that is verifiable from the Wakalatnama,
correct.
which is before.
No difficulty.
Thereafter, the petitioner signed and executed Wakalatnama in favor of his present advocate on record. That much is also part of record. Thereafter, my lord, in counsel was instructed to draft. Now, my lord, I come to para 5. It was thereafter discovered that the erstwhile advocate on record had omitted to apply for the certified copy of the impugned order. My lord, in para 5, this is the only sentence, and if my lord kindly takes Mr. Das's email, he has admitted as much that he had not applied for the certified copy. My lord, my humble
No,
submission
his statement, the explanation is
Yes.
why?
My
Because
lord,
your
which is
client,
why I have made no allegations against the previous. I have
no,
only stated that he has omitted.
the act of omission is also an allegation.
My lord, I have not
It's
stated
a
that it was
a dereliction in discharge
I
of
bow
the
down.
solemn duty
I bow down,
of
lordship.
an advocate on record.
My lord, if I may,
This will not be taken in that, the
lord.
simplest way. This can't be done. sorry, we can't accept in this way. Omission. Omission has a far-reaching consequences. One can go to the bar council and he can make a complaint against him that he omitted.
But my lord, subject to correction. my lord,
That's
section
why I
five-
said that these lawyers must be heard,
My lord,
because ultimately, if somebody goes, then he has to defend, and there is a acceptance by a court. There's a judicial order which accepts those allegations. Then what will happen? Do you realize?
my lord, I bow
Then-
down to everything that is falling from my lord.
Then
My only.
why
humble
not he
submission
should be
is-
heard?
আমায় directly জিজ্ঞেস করেছে, তুমি সেজন্য আমি বলছি।
May I, my lord, take the leave and answer, my lord? My lord, maybe, my lord, if, my lord, this word, my lord, is, my lord, the difficulty, my lord, maybe come back with a fresh application with regard to, my lord, one, my lord. Why, my lord, may I say, my lord? My lord, why, my lord, I'm saying, my lord? My lord, actually, my lord, whatever statement has been there, I was only, no, I've got the letter, I've seen the letter. I was, my lord, I was there before the NCLT. High Court, I was not there at all. I'm coming in the appeal only. Only in the appeal I got briefed, my lord. For the NCLT, I was there, my lord. I've drafted the petition. I know it very well. I can say that even. But High Court, I was not there at all. Never there. Number one. Number two, my lord, is that, my lord,
Where is he?
my lord, he is, my lord, I called him, my lord. He is in Bellevue Hospital, my lord. His mother is going on a dialysis, my lord. So therefore, my lord, he's there in the hospital. And that is the reason, my lord, he has sent the electronic mail. That is the reason, my lord. Because he's, my lord, he says that, my lord, if it is kept at 1:30 odd, or my lord, he will be, my lord, coming from the Bellevue Hospital, my lord. As far, my lord, I have understood from my clients, my lord, there is no allegations as such, anything anymore, my lord. Yes. No allegations, anything anymore.
Where is Mr. Ritobrato Mitro?
My lord, I tried to call him, my lord, I'm not getting through his phone number. I asked my junior to in the bar library also, my lord, he's not there. My lord, he will not be in some other court, my lord. My lord, the paragraph.
Once the bullet is triggered,
It doesn't come back, my lord. Yes, my lord.
what does it mean? Can you bring back? Nor you can divert the route.
My lord, here, my lord, the thing is that erstwhile I didn't get instructions, and my lord, this is oath versus oath, my lord. I don't want to get into it at all. I actually don't want to get into it.
Don't you know when these things used to come when I was on that side of the room? What was my view on that?
I required, my lord, leave, my lord. Even if required, will be.
Never.
But actually, my lord, now, my lord,
Unless inquire from that advocate, if he comes in many of the matters, he comes and admits, yes, there was. No difficulty. No difficulty. We are quite conscious.
my lord, I understood, my lord,
He must be aware that what is being told or said or stated against him.
my lord, the difficulty, my lord, may I say, my lord, what we face, my lord, here, my lord, we are facing, my lord. My lord, we are hearing two persons, my lord. I cannot come and decide who is selling what. I cannot decide that fact.
What?
My lord, I cannot decide that fact who is saying what. My lord, one is saying one is saying one. My lord, I didn't want to get into the space at all.
Something is said, then you'll have to at least make your, because he's a member of the bar.
He's a member of the bar, my lord, a close associate of mine even, my lord.
So
But more reasons, my lord, I'm saying, my lord.
more reasons is that no.
And I don't want it to get into it at all, my lord. That is the reason I'm saying, my lord.
How many days delay?
71 days delay, my lord. That is the reason I didn't want to get into at all whatever is there, my lord. Hmm?
What is the why the fuck is he written by that? Right. চেক করেছে এখন ওদের নাম লিখেছে idiot.
There's one reason, though in the petition, nowhere anything is said. But there is one, the erstwhile
I've just
advocate
seen
and
the mail.
record.
Mr. Malik just showed me the mail, man.
There are certain names which are given, your name is also given. What I am of the firm view is always when a section 5 or restoration,
Lordship allows it, I know.
when a section 5 or a restoration is filed, and in that application, if there is certain aspersions made against the erstwhile advocate, that my firm belief is that unless he is made aware of the aspersions, we should not simpliciter proceed and allow the application. Because ultimately, we are accepting those aspersions and finding it as a sufficient cause, either for restoration or for condonation. And if the lawyer comes and says, yes, this thing has happened, no difficulty. The second reason is why we call it that if these aspersions are accepted, the client or a party may go to the bar council and can make a complaint that these are the fault or the lapses or misconduct on the part of the advocate. Look, the court has also accepted it and condoned or restored. Look at his plight. He doesn't know anything. He did not get even a chance to defend before the court. So that's why we always give a notice, though he's not a party, but give a notice that you come and disclose. Sometimes they come and accept, no problem in proceeding. Now this is a case where
No, but from what I could see of the mail, my lord, I am not concerned
only
with
thing
what
is-
happened, my lord,
No, no.
between the advocate on record
there,
and my lord, the
there-
client.
there are certain things which are said about you as well. In
No,
this
but
mail.
that has nothing to do with the delay.
No. It is something that what happened and what was going to happen was happening between the client and the advocate. That advocate and record has also indicated that you are aware of all these facts. You are aware of. Can you read that?
Yes, my lord, kindly give me a moment, my lord.
The very first line, your name is there.
Yes. And that's correct. We endeavored to finish the matter. The assertion in the first line is nothing but contrary to what I've done.
The second line.
Yes, my lord. No. My lord,
Then third sentence.
no, my lord,
Then fourth line is
I'll
you.
tell you, my lord, what happened. There was some tiff between the advocate on record and the client. I am told he refused to pay the fees, which is
That
why
he has indicated
which is why
twice.
the tiff happened. I am told by him he didn't hurl abuses at me. There's no reason for me to make that aspersion.
That has not been said.
So no, I wouldn't know because he has written that abuses and I was offended.
Abuses somebody else.
No. He's saying he abused and I was offended by the abuse to somebody else. Now, my lord,
Obviously, because the abuses has been hurled to somebody.
yes,
You
that
should be offended.
I was offended.
Yes,
When
you
that,
should be.
yes,
That's
Yes,
the
my lord.
expectation from you.
That
You
is
should be offended.
correct. And that is when, my lord, I said, I don't want to do this matter if this is the attitude. I made it very clear. He, my lord, thereafter came to the chamber. He said, I'm very sorry. Please complete the matter. So I completed the matter. There was a second limb to it where he refused to pay fees because he said, no, not substantial hearing. So I won't pay the fees. So I said, very well, let us get it over with. Let me complete the matter since I've started. But beyond that, my lord, after the matter was over, my lord, I am not concerned with. My stand is clear, my lord. I have the first hearing at what No, I don't want.
Madam, then how I will believe that paragraph 5 sentence? Because if that being the position that he was simply requested to continue with the hearing and put an end to the hearing. He put an end to the hearing and thereafter nothing was required to be done. It was your client who has to take immediate steps, which he took the immediate steps by taking all the briefs without taking a no objection. So if your client did not instruct the erstwhile advocate and record to apply for certified copy, how can you stand by that statement, omit it to file the certified copy? Tell me. How you will justify the stand? Because this letter says only, and Mr. Mitro also is very candid that only just to, since I have started, I must complete. He completed it and thereafter he has no role to play. Now he says that immediately thereafter the brief was handed over. Then where is the omission on his part? If the client does not instruct him to apply, is it a duty of the lawyer to immediately apply for certified copy?
Submissions. As the present advocate on record, I have no way, my lord is absolutely right, of ascertaining whether my client did in fact instruct the prior advocate on record to apply or whether it was an omission on his part. My lord, two things, my lord is very much aware. The application for drawing up and completion is to be given within 7 days of the order being passed. My lord, today there remains only this gray area, whether he was instructed to apply and he omitted, or since the client took away the briefs, he naturally assumed.
Obviously, immediately, that is what it says.
But my lord,
Immediately when the matter, they finished the argument, this was handed over.
my lord is aware, the process of handing over is not so easy, especially on the original side.
No, it is always very easy. Somebody may take away the briefs. Only question is whether he has been, taken off or, the no objection has been given or not. This no objection was not secured by him.
My lord, in that
And later on, you called him up and then say, my client has executed. I am sending you a duly executed wakalatnama. You put a no objection on that.
well within his right to withhold the objection. That is the practice.
No, madam. If you inculcate this, I am telling you wrong notion.
No, my lord, we kindly.
You can't withhold the no objection. If the client wants to withdraw, you should.
My lord does not take me amiss. My lord kindly allows me to complete. When I called him for the no objection, my lord, he was well within his right to say, look here, you send it, but this is the fact of the matter. None of this, my lord, if the issue comes
As a
from
good,
knowledge,
as a good advocate and record, nobody would say to another brother.
please inform me that there is no certified copy. He's taken away the brief.
No, because everything has been taken away. And when you take a no objections, is it not your duty to see that what has happened?
Yes, my lord.
Yes.
No,
Yes. No, sir.
immediately applied.
That did you ask your client whether you instructed him to apply?
His submission was now, my lord. The only thing I request my lord to
Then it's an oath versus oath, and whom to believe? It's a I would say the legal fraternity. whom we believe because they are the officer of the court.
I have.
So disbelieving an officer of the court is a very tough task.
my lord, kindly, my lord, kindly, my lord,
No, definitely
kindly,
not.
lordship, my lord.
Definitely
My lord,
not.
does not go, my lord,
It will go a very bad message and a very wrong signal to the entire legal
my
fraternity.
lord, may I do one thing, my lord? May I do one thing, my lord? Kindly allows this, my lord. Kindly, my lord, let me withdraw, my lord. Let me take out a fresh application, my lord, with regard to, my lord. Or my lord, let me amend it. Kindly give leave to amend. Because, my lord,
I tell you very frankly, we are very liberal. As Mr. Mitro has said, so far as a restoration, so far as a condonation, because our view is, and that is also a view expressed in many judgments of the Supreme Court, that at least let this matter be decided on merit. If there is some good matters on a limitation point should not be thrown out. If we can find certain grounds, which are sufficient enough. It's not that without any ground we can't. There are certain grounds which is a question of belief and disbelief. But in these kind of things, that's the whole problem.
my lord,
The problem. Had it been some other thing, no problem.
my lord, what happened transpired between the two persons, my lord. I actually don't want to, no one knows, my lord. That is what, my lord, that's the reason, my lord. One statement, my lord, as my lord has already, as what my lord has already stated in oath versus oath, my lord. It's true, my lord. I already indicated, my lord. Kindly, my lord, does not take any word, my lord.
It does not appear to be true. Because of this email, it does not appear to be true.
My lord,
And Mr. Mitro is also very, I would say, senior
yes, my
person.
lord. What, my lord?
Yes, frequently. If he has said something, then how can you?
My lord, whatever he is,
Because he says that there was some disputes which was
there was
going on
dispute. I also know
between
about the dispute that there was dispute.
between your client and the erstwhile advocate in record. Because he was in the midst of an argument. Then your client approached him and say on a humanitarian ground that is said they please complete it. So I wanted that once you have started complete. He says no difficulty. Once I have started, only I will complete it, and thereafter I will not take up any of your matters.
Yes, my lord.
He completed the argument, and immediately thereafter the entire brief was taken away or was handed over to your client. That is what these statements are. But he also said that he insisted that you take a no objection. He did not take a no objection. Look at it.
But,
Look at it.
I don't think so. It was
Yes,
there, my
to
lord.
take brief. Communications are there in the WhatsApp.
That what is, he has only collected
Then
the
he had
brief
neither
and
taken
the
a
NOC of
please.
the
He has neither
SLT
taken a
matter.
no objection nor he did request me to apply for a certified copy.
My lord, may I say, I don't think, my lord,
He had only collected the briefs and the NOC of NOC for the NCLT matter.
My lord,
Then later on,
I'm going to check you.
you called him, she, and then send the Vakalatnama. He put a no objection on that.
Lord, may I say something, my lord?
What he will do?
May I say something, my lord?
If a lawyer has sent it saying that yes, the client wants, fair enough. It was a very good stand on his part that immediately it put his no objection and handed to.
Lord. Lord, my lord, kindly does not take any word. Amiss, my lord, kindly does not take any word. My lord, kindly.
That's why I asked, where is your client?
My lord, ask him, call him up and ask. Call him up and ask. ठीक है, ठीक है. My lord, may I, my lord, make a request, my lord? My lord, kindly, my lord, expunges that paragraph 5, my lord, of the application, my lord. Kindly, my lord.
How can you expunge it? It is a statement of your client,
My lord,
which is
kindly, my lord,
affirmed to be true to his knowledge in the affirmative. Can you expunge it?
my lord, kindly delete the
Unless
paragraph.
he comes and says that I want to expunge it. I do not want to make. How can you do it? I can understand prayer portion. I can understand any other preambles. You can
My lord, I'm
expunge
trying
it.
to contact my clients, my lord, if they will come up and do it.
But so far as the affidavit, I think it is verified and true to his knowledge. Paragraph
Have to
5.
be, my lord, should be, my lord,
Yes.
should be, my lord.
How it has been affirmed?
To my knowledge.
Have to be true to my knowledge, my lord.
To my
Have
knowledge.
to be true to my knowledge.
Yes. So
Have to be true to my knowledge.
so
My lord, kindly expunges and my lord, kindly, my lord. My lord has the power, my lord, to expunge a paragraph, my lord, of the
how can you expunge? This is a statement of your client.
expunging?
Supplementary.
Lord, maybe file a supplementary affidavit where we will specifically state to expunge the paragraph, to seek expunge, withdrawing all statements of paragraph 5 made in this application, my lord.
What instruction your junior has? He is unable to come.
My lord, kindly, my lord, allows me to supplementary affidavit, my lord, for expunging that, specifically that paragraph, my lord, and all aspersions, my lord, also, my lord, nothing, if any,
When
my lord, my lord, kindly, my lord, allows, my lord.
can you do it today?
My lord, today, my lord, try, my lord. আসতে পারবে আজকে? My lord, today itself I'll do it, my lord. If he can come, my lord, let me see, my lord, because he's also, my lord, an old man, my lord. Old age. I mean, boys to দেখি দিচ্ছি। My lord, 72 years, my lord, that's the reason, my lord, old, my lord, senior citizen. So. Regard to, my lord, kindly, my lord, allows, my lord. Kindly, my lord. Grateful, my lord. Grateful.
Lord, I have seen it in court number 37. Lordship follows this principle, my lord. It is between the court and the appellant, my lord. Lordship had called the lawyer. He came in court, and in fact, in that matter, he said I had not given
Come
the
with the
consent.
supplementary affidavit at 2. Call your clients.
My lord, 2.
Come at 2.
Lord,
One paragraph supplementary affidavit come.
আসতে পারবে দুটো সময়?
Come. 2 p.m. Yes. 2 p.m. Come. Let us see.
My lord, come at 2, my lord, try, my lord.
Grateful.
Come at 2.
Grateful.
Call the next.
Immediately done.
For the official liquidator.
I appear for the appellant, my lord. Affidavit of Lord, have challenged an order of my lord the transfer of winding up proceeding.
I have seen that.
Lord,
There is a
there
delay of 72
72
days.
Lord, we were not party to the initially in the proceeding. I'm a
And it's
creditor
a
of the
suo
company.
motu transfer, my lord.
So you were not a party, then how can you maintain the appeal?
Lord, I am a creditor of the company.
So what?
Milord, once Milord, the creditor of the company can file an application, Milord, for Milord transfer, he has the right also to Milord the.
Correct. So you have to go and file an application for transfer.
No, Milord, I don't want to matter.
You
to
don't want
transfer.
to, then you'll have to, when you challenge any order which has been passed, then you'll have to seek a leave of the court.
That we have this.
Where is the leave?
The stay application.
Stay application is a leave.
Milord,
Leave to file appeal.
my lord, we, as an intervener, my lord.
Is,
Yes, my
how
lord,
can it be done?
my lord, you'll see, my lord. If we
All
granted to the-
composite, all composite. Several independent reliefs are claimed in a one application.
with the undertaking, my lord. With the, my lord, we have sought.
One is a leave to prefer an appeal. Another is the stay of the operation of the order. Two distinct things. If the leave is not granted, there is no question of any stay. You know, there is one judgment of the single bench against you. Justice Pratap Kumar Ray. Is nowhere reported except in ICC. More than two independent prayers cannot be made in one application. Two independent cannot be made in one application. So, composite. When the other matters are fixed for hearing?
Case of matter was heard by your lordships in extenso, but your lordships, there were other matters tagged
No,
with
no,
the
this
Jessup.
is on a suo motu power.
This is the suo motu, your lordship,
That
but
is
in
what
the
I'm
month of
asking.
June, my lord.
You are also appearing in that. When?
All fixed
No,
in
no,
month of
suo motu
June.
matters we were trying to take. How you will be affected by how you are affected by this order? You have not said. All irreversible situation, irreversible situation. You should affect that. In
But
the
my
event this
amount
has
was
gone there, your claim would be.
Lord, my amount was admitted, entire proceedings was carried out.
But you will say that how you will be prejudiced by that.
My lord,
Everything is irreversible situation, irreversible situation. Where you have stated
my lord,
that how this order affects your right.
because
I just wanted to know
my lord,
where your oral submission will not do. Tell us from your statement. I know how you will be affected. Tell us from the pleading.
my lord, it only said, my lord, that my
This is a very careless manner. You have to say that your claim has been admitted, and in the event it will go there. Then the CIRP proceedings will be initiated, and your claim would be defeated. And therefore, you are vitally affected by this. There, you will not say that. Your claim would be effaced, or at the bottom. Very easy way of drafting. The appellant being the creditor of the company, whose claim has been admitted by the official liquidator, has filed the instant appeal challenging the the order dated 30th January 2023, by which the winding up proceeding was directed to be transferred to National Company Law Tribunal, Kolkata, by exercising the suo motu powers conferred under section 400.
434.
There is a proviso 7 or something.
5.
Please.
5.
400.
34. Proviso 5.
Four hundred and 35.
30 proviso 5.
430 by extent of power, power under section 435 of the Companies Act 2013.
434
Proviso 5.
Oh, sorry, 430. I'm standing. I am just looking at the top. 434. 434. You're correct. Uh, 1, 2, 3, 4. 1, 2. By virtue of an amendment having brought with effect from 6/6/2018, the fifth proviso to section 434 within bracket 1, subsection 1 of the said act was introduced in relation to a winding up proceeding which is pending before any court, to be dealt with by the said tribunal, may be transferred on an application proceedings to the tribunals suo motu, or such proviso would only be activated on an application filed by any party or parties to a said proceeding. We are quite conscious that the moment the winding up proceeding is transferred to the tribunal for initiation of
corporate insolvency.
There is a language used
Corporate insolvency.
for initiation of corporate insolvency resolution process under the IBC. It would vitally affect the claim of the petitioner. We therefore find that the petitioner / appellant is there is appellant satisfies is the satisfies the ingredients of within court the person aggrieved unquote and therefore has a right to challenge the said order. In view of the above, the leave to file appeal is granted. Next. It appears that the instant appeal has been filed beyond the statutory period provided therefore. The circumstances narrated in several paragraphs in seriatim discloses the reasons for non-filing of the appeal within the statutory period, which appears to be satisfactory. Accordingly, the delay in filing the appeal is hereby condoned. The office is directed to formally register the appeal. Stop. Considering the nature of the order and the consequences which may follow therefrom, if the operation of the order is not stayed, it would not only affect the right of the appellant vitally, but also render the instant appeal infructuous. And therefore, it is a fit case where we should grant the stay of the operation of the order. Accordingly, there shall be stay of the operation of the impugned order for a period of 10 weeks from date or until further order, whichever is earlier. Have to be very careful. He will nod the head because he got the order, so he never understood. Ulta. Ah. Application to রেখে দাও যাতে application adjourn motion এ চলে আসবে এই অ্যাপ্লিকটা ডিসপোজ হয়ে যায় তাহলে অ্যাপিলে অনেক ফর্মালিটি হবে প্রবলেম application condonation stay is separate.
Yes, my lord. Condonation and stay is separate. We have filed an application for condonation of delay. If you want,
স্টেটাকে রিটার্নেবল করে দাও condonation allows stay application to return after when those matters are listed.
Month of June, my lord. But I cannot apprise your lordship with regard to the date.
I know the dates are going to give to a lot of offices. So we can't fix a date because if those are fixed earlier, then it can't be listed earlier. 1 week after application, 1 week after the reopening of this court following celebration. Stay application.
my lord, paper books.
Informal.
Not necessary. It's a pure question of law. That's why we are keeping the application alive so that we can hear out the appeal and dispose of. Yes, Passover matter.
Grateful, my lord, for granting me a passover, my lord. This matter, my lord, relates to a very short question, my lord. The suit, my lord, was filed, my lord, before, my lord, the commercial division, my lord, came up. My lord,
Short question is a very important question.
Very important.
You have to answer.
Sir.
We want to hear it. You have to answer because those amendments have been brought. Order 11, Rule 1, Sub Rule 5. I have read the brief yesterday. Don't worry. I have read it. Truth of statements. There is already everything is there. Now, whether this provision can be said to be directory or the provision has to be read as mandatory. There are certain judgments which have said.
my lord, in fact, my lord, from
Mandatory.
our courts, my lord, this Bhakti Hari Nayak, Bhakti Hari Nayak, my lord, is one of the.
I do not know whether the Supreme Court has said because all these time limits which have been given under the Commercial Courts Act are always considered to be a mandatory one.
My lord, here it is.
For the filing of written statement, it says cannot go beyond. Now,
Yes.
language of this subsection 5, which is quoted, the entire section is quoted in the impugned order.
Yes. My lord,
An
there, my lord, it
admitted
says-
position is that this documents relates to 2011 to 2015, prior to the institution of the suit.
But we said, my lord, at that time, my lord, there was no requirement, but my lord, here, my lord,
I do not know. The subsection subrule 5 says the plaintiff shall not be allowed to rely on documents which were in the plaintiff's power, possession. That is, his entire section is quoted
yes,
in the impugned order. Come to page 9. Impugned order, page 9.
yes,
Plaintiff shall not be allowed to rely on documents which were in the plaintiff's power, possession, control, or custody and not disclosed along with the plaintiff or within the extended period set out above, save and except by the leave of the court. And such leave shall be granted only upon the plaintiff establishing reasonable cause for non-disclosure along with the plaintiff.
here, my lord,
So what I find is that there is some kind of a discretion left to the
yes, yes.
You did not have to. I said. Now the discretion has to be exercised judicially. Now, considering the object and purpose of the act itself, Commercial Courts Act, where all the time-bound things are placed, whether the discretion has to be exercised
Strictly, very strictly, or my lord,
to
there
a
can be some
stricter sense or in a
some relaxation can be.
more liberal sense.
The additional fact, my lord, here may be that, my lord, the suit was originally, my lord, when instituted, my lord, was, my lord, before
I want to hear this.
non-commercial.
It's a important. I do not know whether any judgment is
So, my lord,
there
on
of a
this
direct.
particular issue, my lord, no. But, my lord, the 99 amendments, my lord, will recall, my lord, when they came up
That
with
I
that
know.
affidavit, that is Bhakti Hari Nayak.
Hari Nayak is a different one.
So that's all, my lord, the
Who argued?
affidavit. My lord, before justice, my lord,
Ashok Kumar.
I was also my lord, one of the parties. My lord, so
I was. On the very first day, I was there. And this relates to a Chatterjee International.
yes, yes.
I was appearing for the association throughout. I was appearing to oppose you. It was a Gupta's matter.
Yes, my lord. Absolutely, my lord.
I'm telling you that I was there. So there what happened is, that was a point which we took. I think Mr. Mitro, the senior
Yes,
Mitro was
yes,
appearing
yes.
there. The point which was taken by us was that after this 2002 amendment, if the the verification like a winding up petition that you'll have to, what is the terminology which is used? Affidavit verifying or what is it?
Verifying petition, my lord, the, sorry, in
Verifying,
support of, my lord, the,
verifying, yes, in support of the verification. That was introduced and that was not there. It was a simple verification part.
Correct.
Without any affidavit.
correct, absolutely.
Then the question arose whether this provision is a mandatory
Mandatory
provision or it's a directory provision. Single bench held mandatory. No, single
Single
bench
bench
held directory.
The
And
division
the
bench, my lord,
division
was
bench
successful.
where
That's-
I was introduced. We argued
bench
that it
held-
is a mandatory provision.
Yes, yes.
So that was thrown
Dismissed.
out.
So-
Thrown
so
out.
was dismissed.
Yes, dismissed. The matter went.
Set aside.
The matter went up. And the Supreme Court in that report says it is directory. It's mere a
Correct.
procedural
Absolutely.
part. You can't dismiss it. This is a curable.
It's
Justice Ganguly's view was incurable defect.
That's right.
And the Supreme Court said it's a curable. This
Curable.
is something different. Here that principle does not apply.
Here, my lord, it's really on the question of, my lord, that
The
discretion
question
is
is
with court.
discretion.
discretion is with court to grant the leave.
Now, there are two things, discretion. It is always left to the court. The only catchwords are, must be judicious, discretion must be judicious,
Yes.
and must be reasonable. Not capricious, arbitrary,
Yes. Reasonable.
but there is no longitude or a latitude which is given of that discretion. But considering the object of the Commercial Courts Act, I think discretion, while exercising the discretion, the court should also keep that in mind.
But perhaps, my lord, some
I believe so.
strict.
I believe so. More more stricter or a strict way of doing it.
My lord, the suit has, my lord, there's also, my lord, surrounding circumstances, my lord, which might require that, my lord, the stage of the suit, my lord, the proceeding originally.
That's my prima facie
And
observation.
my lord, there's no denial, my
I'm
lord,
not
to the,
using nowadays the word tentative observation, but I'm using the word prima facie observation.
my lord, there's no denial, my lord, to the documents as well. The contents of the documents, my lord, are not denied.
Yes,
Contents of the documents are also, my lord, not denied.
not?
Not denied. It's not that, my lord, as in, my lord, the contents, the documents which we want to produce in paragraph 10, my lord, it is given in our application. You must have seen it. My lord, I'm saying, my lord, these are all factors, my lord.
You don't have a direct judgment on that.
My lord, there are, my lord, none of the, my lord, Honorable Supreme Court will look again. But, my lord, there are some, my lord, judgments, my lord, which say what is a reasonable cause, my lord, of the Madras High Court, my lord, and, my lord,
Our high courts,
our High Court, my lord, my lord, one, did you issue the no? My lord, one of, my lord, the learned single judge, my lord, where, my lord, order 8 on, my lord, defendant wanting, my lord, to disclose, my lord, in a suit.
same thing,
There also, my lord, there
identical.
it was, my lord, permitted.
I tell you, when 2002 amendment came, the provision in the Code of Civil Procedure, like very easy provision, that was also deleted. That was also deleted.
But
But reintroduced with in a new
in
getup.
a new avatar. But our submission is perhaps, my lord, that my lord, fact that, my lord, 30 days and then, my lord, a registration is given to court, and we'll have to look at the surrounding circumstances, my lord, really.
I was saying, my lord, kindly takes it up after the vacation, but reasonable cause, my lord, that has no, in their petition, they pleaded 2 things as reasonable cause. Those have been, my lord, in subsequent decisions, or rather prior decisions also of the Honorable Delhi High Court, my lord, those have been held to be not good enough as reasonable cause. One is, my lord, that they were under the impression that the suit would proceed not in accordance to with the Commercial Courts Act. That is one. And the second one, my lord, someone left their employment.
Not a good ground, because under the, if the suit is guided by the original side rules, then in that event, if there is no fetter, then in that event, can he not take a plea that it was a converted suit?
Converted, yes, yes.
And the moment it is converted from a original side to another commercial division, then immediately thereafter they took out.
No, not immediately. Much later. Much later.
Much later, about 8
months. 8 months
or 8
later, my
months.
lord.
Correct. That is the
8
factually
months
that is.
later, yes. So that is the, and the person, they've taken a plea, my lord, that the person in their employment who was looking after these matters had left their employment. Whereas the plaint and this application has been affirmed by the same person.
Then
that is what
you have done.
But I
You have taken a plea that he left the employment, and then the
some other
application is
person
affirmed by him.
Some other person had left, but this person who has affirmed the petition was in their employment.
But then
He had, my lord.
some other person, and that's
Yes.
what they said. One of the ground. I got the impression, my lord, the
You
same.
are
not the same
I
person.
got the same
No,
person.
not the
I
same.
also got
Also-
nervous.
Not the same
I
person.
was taken aback that
No.
what is this?
Oh,
this
my
happening?
lord, perhaps I was not, my lord. These are, and I cited, my lord, 4 decisions, my lord, where I can cite those again before your
I
lordship.
want to hear out when
Lord, whenever, my lord, is convenient. My lord.
on the reopening, that is on 6th.
7th, my lord.
Or
7th.
right?
No, we are reopening on 5th.
We are reopening on 5th. My lord, 7th is already.
And Tuesday is the day for us in the side.
8th, my lord, then. Very well. On 6th is
6th.
fine. Yes.
On 6th. The moot question involved in the instant appeal is whether the amended provision, whether the provision contained under Order 11, Rule 1 within bracket 5 of the Code of Civil Procedure subsequently amended for the purpose of its applicability to a commercial suits. To commercial suits, to the suits filed under the Commercial Courts Act 2015 is mandatory or directory in nature. The ancillary point sprung therefrom relates to whether the stricter view now is stricter principles to be applied in exercising the discretionary power conferred under the aforesaid provision, keeping in mind the object and the purpose of incorporating Commercial Courts Act 2015.
Malad, this is my submission, Malad. I'm sorry, Malad. That Malad, the surrounding Malad, all other factors should also be considered, Malad, in the question of Malad granting discretion. Malad, that's Malad.
No, that is what is always I said. Whether a stricter or a liberal,
Stricter or liberal, yes.
stricter principle or the liberal.
Yes.
Stricter or liberal principles to be applied. Let this application and appeal be listed on 6 June 2023.
Six. Grateful.
What is your view, Mr. Mitro?
I am totally, the Lordship is against technical. Come to the board. Technicality, I personally, I don't like technical. Short of jurisdiction. Look, Lordship is here to do justice, not to.
What is that legal maxim? Ut res magis, veliet quam periet. Find out.
Yes.
UT ut RES res ut res magis MAGIS veliet quam periet. I do not know. Just
Malad,
struck.
no,
I may
that's
be wrong. I may be
No,
wrong.
no, Malad, that Latin. Malad.
I may be wrong. Yes, we
law survives. That's my lord the meaning. And my lord, that's the ut res magis valiat
Quam period.
and my lord, but
I
here,
pronounce it atres magis.
ut res, my lord,
Valiat quam period.
the Latin is my lord, something my lord, which I'm sure my lord,
The law should not bend by the triflings of the technicalities, if I correctly
but the
phrase it.
other one, my lord, of course, my lord, we were looking at, my lord, is the fiat justitia ruet caelium, which is, my lord, let justice be done, my lord, regardless of, my lord, consequences. And, my lord, also, my lord,
That is, the consequences is different. The
my lord, we are also relying on, my lord,
technicalities.
that we have got some, my lord, judgment which we wanted to cite, my lord, that procedural laws, my lord, perhaps, my lord, there will be a liberal interpretation, my lord, so far as procedural laws are concerned. My lord, there are, my lord, including, my lord, 2020 Supreme Court.
No, I know the reverse judgment of the Constitution bench.
My lord, 2020 Supreme Court, including that, my last one, my lord, on the
So
on
the
this point.
Manohar Lal Chopra's case is a different one.
My lord, we'll come back and, my lord, try and, my lord, live another day, as they say.
Yes. More academic.
We have to,
Come.
my lord, get disclosure of the document, my lord. That's, my lord,
Yes, please.
that's, my lord,
Yes, come.
grateful.
My lord, at the risk of being reprimanded, my lord, may I seek your lordship's leave, my lord, to file, my lord, with
Why you want to be reprimanded?
no, my lord,
Why you will invite a reprimandation?
no, my lord, I was just, my lord, we don't have a certified
No,
copy, my lord.
We don't love to reprimand, nor we invite a situation to reprimand. Why should we? So if you think that you will be reprimanded, then don't invite the situation.
No, my lord, the prayer was innocuous, so, my lord,
No, innocuous, then why reprimandation?
then, my lord, with some trepidation, may I make a prayer, my lord,
No.
for leave to file without a certified copy? I have got the photostat of the certified copy ready with me. May I just file it?
Why didn't you come in the morning?
No, there was some miscommunication, my lord, regarding when the hearing would be held. My lord,
Then let there be a proper communication tomorrow morning.
oblige, your lordship. I'll come back tomorrow then.
Hello, I beg to appear on behalf of the respondent number 1, my lord.
Mr. Mukherjee, in the morning, somebody mentioned, I believe, appearing for your client, some junior, that matter where the State Acquisition Act and the Land Reforms Act, that provision, you argued.
Yes,
So
my lord.
I said, we have already completed the dictation. You can't impose something. It
No,
is
I'm not. It was without my consent.
delivered.
He out of his anxiety. He out of his anxiety did it, my lord. I didn't instruct.
Yes.
But I am responsible for everything. Kindly excuse
The
me.
junior is still standing and he.
Okay. I don't know, my lord. I didn't instruct. But he had a written submission prepared by.
Yes. What is this matter?
This is the matter where Lordship demand steel casting section 4C permission. Our LRTT appeal. In the LRTT appeal, an interim order was passed. Basically, the order which was subsisting from the section 54 stage. The section
Yes,
54 to the
yes,
interim, because there was no reasons, the order was set aside only on that ground.
Yes.
And said,
Mr. Mukherjee, on the yesterday when this matter was taken up, I must be very candid to you, subject to what you will say. We find that there is again no discussion in that regard. And the court has proceeded to dismiss. Two things I know. While granting an injunction, the court must record a reason. But whether while rejecting an application, the court should also record a reason, maybe some issue, I do not know. But right to know reason is paramount in both the cases. If we go by that if the order does not contain a reason, then in that event, why?
May I make my submissions, my lord?
Yes.
My lord, for your lordship's
Your
convenience.
immediate junior was not able to satisfy us on yesterday.
He's a very fair lawyer, so I'm sure Mr. Basu
What do you
will-
think? The Mr. Mukherjee
No.
is not, what are you
I'm
saying?
extremely unfair, I admit.
No, I do
will
not,
not
ac-
concede.
no,
He's unfair to me.
no, I do not accept that.
But Mr. Basu is even more fair.
No,
Mr. Basu was not possibly prepared.
it is really a legacy which, it is a legacy which passes through.
I was not ready.
So-
Then if he was
No, consider it's a legacy which passes through. And the legacy passes through the predecessors. He is a predecessor.
no doubt,
So,
no doubt.
yes,
May I make my humble submissions, my lord?
yes.
The facts, only the facts first. About 7.07 acres of land are involved. Belong to Indian Oxygen. They were carrying on industrial business.
Can you keep your audio system closer to your mouth?
Now, my lord, am I clear, my lord?
It can be enhanced from here also.
এই এটা ম্যাক্সিমাম করে দাও তো অডিও তোমার ভলিউমটা সাউন্ড ভলিউম
Am I audible now, my lord?
not audible but
Crack, there's some cracking.
oh, it is already maximum. It's maximum.
My lord, I think, my lord, now I'll be audible clearly. Kindly, my lord.
Yes.
My lord, 7.07 acres of land are involved in this case. No longer involved. Originally, it was involved. A 7 acres of land was owned by Indian Oxygen. They were carrying out their industrial business on this plot of land. Around 1990, my client purchased this plot, around 7 acres.
Mr. Mukherjee, the facts are known because in one of the case we have already delivered a judgment.
Not a judgment, not extensive
facts.
discussion.
This case only, my lord. This case
Only
only.
thing I,
We know it. That's why we are saying.
But his endeavor is to give the reason and to say that reason is already there. That's
Oh.
why
Mr. Basu, will you kindly permit me to make my submissions?
Yes.
Ram
Thank you,
Lord,
Mr. Mukherjee. Thank you, Mr. Mukherjee.
my lord, what is here? Point, why I was narrating the facts, I never applied under 4C, though that clause is mentioned so on and so.
For conversion of the nature of the property.
No.
4C means what?
It is used for industrial purpose.
That
from
is
the
what
date
is a conversion. It's a conversion of the nature of the property means from maybe from agriculture to industrial or maybe from bastu to a pond or a whatever.
I was putting it in this way, my lord, in my own humble way, for correction of the entry in the records. Reality was there, industrial. But the records, it is recorded as Shali. In their case, Mr. Mitra's land is also recorded as Shali. My land is recorded as Shali. For last 40 years, we are using it for industrial. For correction of the entry, not touching the reality. I made an application. BLR applied, allowed it. Commissioner allowed it. The tribunal on the first occasion, merely because an appeal was filed, stayed. I came to your lordship. Your lordship had the pleasure to hear the matter at length, deliver a lengthy judgment, incorporating all the facts, but recording that the reasons given, the tribunal has not given any reason, send it back. Other point was, Mr. Mitra's client wanted to place the facts, wanted to file an application. We go back. Mr. Mitra's client files a lengthy application. And this time, the tribunal records the principles for grant of injunction or refusal of injunction, finds no prima facie case, finds balance of convenience in my favor, finds that there will be no irreparable loss, his injunction is required.
There is the question whether he really finds.
My lord, I will supply, my lord, I'll make my submissions.
Yes.
My lord, he has recorded these facts, conclusions. He had the advantage now of the collection of facts by your lordship in your lordship's judgment. He has referred to it. On that basis, my lord, he has drawn his conclusion. What is the prejudice suffered by Mr. Klein? He is using it for industrial, recorded as shall. I am using for industrial.
If I correctly remember, their property was initially your property.
No.
Was
Yes.
sold to them. That was sold to
I sold a part of it, yes.
and they were using it, even if it was Shali, they were using it for industrial purposes.
I am also doing it.
Now you wanted, if I correctly remember the facts, that you wanted to set up an industrial park. So you say that it was all along used as industrial purposes, and therefore, even if there is an entry, but it was always intended to be used.
I can't put it in a better way, my lord. These are the facts.
Memorial, since the time immemorial.
And that is being objected.
And now the moment you wanted to set up, they are now coming, who is also using the land. So they cannot take the advantage of that. That was, if I correctly remember, was an argument on the last.
Absolutely correct.
Yes.
I can't put it in a better way. Now, my lord, how do they feel prejudiced? Whatever reason given or not given, they are using it, I am using it. Only their entry is to be corrected, not conversion.
So the principle of live and let live.
Yes.
Yes.
And that's what your lordship has collected all the facts. The tribunal said no injunction this time. I am also have some other point for lordship's kind consideration.
Mukherjee, the only thing is that he reproduced the entire facts in earlier preceding paragraphs, but surreptitiously jumped to the conclusion without saying anything whether what is the prima facie case, what is not a prima facie case, why the balance of convenience and inconvenience does not lie in their favor. All these things have to be spelled out. Nothing has come out in the impugned judgment, impugned order.
May I make my submissions to your lordship? I enjoy the advantage of addressing appeal court. Your lordship is presiding over an appeal court. If there is any deficiency in the judgment of the trial court, but all the facts are dealt with, all the facts are on record, your lordship may be pleased to supply make up the deficiency.
That we can do it.
Kindly recall the principle, my lord, of section 100.
We are aware, but
No, but, my lord, that is the judgment of your lordship. Not on that ground. That all records are there. All facts are there. But the trial court has committed mistake by not writing a good judgment, not giving an elaborate reasons. Your lordship in the appeal court while make up the deficiency. My lord, when your lordship was in a bar, I think your lordship relied upon a judgment. I have relied upon on a number of occasions. That's a judgment of Sir John Ranking, sitting with Justice Ashutosh Mukherjee. That when all the facts are there, don't remand it back. We challenge this remand order in the revisional matter, very often citing this judgment. Facts are there, all facts. If the trial court has committed wrong in passing an order, your lordship will kindly make up the deficiency. Only for this reason, your lordship's judgment was the basis of his conclusion, but he didn't deal with it. He's not prejudiced. All facts are there.
I understand.
Only entry, correction of the entry.
No, I am still aware of it, because if I dictated the judgment, I know I have read it. So that's why I say it always there in my mind. But what I find from this particular order was that he reproduced the facts, submissions of the counsels, and then if you come to the pagination is not here. I believe 1, 2, and 3rd page of the order impugned here. where the paragraph begins with heard and considered.
Yes.
And thereafter he says, as directed by their lordships in the stated pronouncement regarding the peripheral of the settled proposition of law concerning interim orders, we are now to consider such prayer of the appellant company vis-a-vis the golden principles governing the stay order ordained by the Honorable Apex Court. Then he says principles he narrated, whether 1, 2, 3, 4.
Out of respect for your lordship, out of respect for your lordship, you have also demanded it back. Give a good judgment, reasons. Yes, quoted from text.
Secondly, then he proceeded, it is averred in the instant way that the applicant is a leading global company manufacturing and selling ductile iron pipes and fittings required for drinking water transportation, continuing with their manufacturing activities being carried out from its factory at such and such place, adjacent to the case land of the respondent number 1, and the applicant is interested in the case land required for expansion. So this is what he narrated from the pleading. Then he quoted the excerpts from the pleading. He quoted it. Then he says the appellant company therefore submitted stating that the case land is required by them for expansion of their existing manufacturing activities, which however, if any, is to be considered by the government of such and such beyond the jurisdiction of the tribunal. This is what appears to me the submission. And then vehemently objection was raised relating to the proceeding under section 4C, that facts. And then the facts was narrated. Then he quoted the excerpts. Then the appellant company has preferred the writ petition. Then he quoted the fact that it is pending. And then he surreptitiously jumped to the conclusion that in view of the aforesaid stated facts, it reveals to us that the appellant's instant company failed to make a prima facie case. Now, where he has recorded that what is required for the purpose of prima facie case. You know that Supreme Court judgment Manohar Lal Chopra, where what is the meaning of the prima facie case. Then you know 1982 Supreme Court distinction between prima facie case and prima facie title, not to be confused together.
My lord, I made my submission. Facts are not in dispute. Facts are on the record. And the facts have been collected in your lordship's judgment. If there is any deficiency in the matter of conclusion, your lordship will kindly make it up. And kindly have a look at this historic judgment, my lord, of Sajjad Rankin and Sir Ashutosh Mukherjee.
No, that we are aware that if the ultimate conclusion is found to be correct, then there is no difficulty on the part of the appellate court.
All facts are on the table. All facts. No dispute about facts. And only correction of the entry. That's for your lordship to consider. Only correction of entry. We are all using it for industrial purpose.
But that does not come under 4C.
That's it. It doesn't come under 4C. That's what I'm telling your lordship. It's really not 4C. It's a correction of an entry. And if then that view of the matter, my lord, kindly go back to your lordship's power and section and subsection 2 of the Civil Procedure Code.
Yes.
Any deficiency your lordship will make up. For that again lengthy argument. My landfill's client is a very powerful entity in the industrial board. I have come to a halt. I can't carry on my business. I'm trying to convert into an industrial park.
Much bigger than us.
No. My lord, Mr. Mitra will take it there. I know his client.
Mr. Mukherjee knows my client very well. He's done so many matters for my clients. He knows very well.
Take your seat kindly.
As you
This is the point. Kindly have a look at your lordship's own judgment. Kindly look at the trial court judgment. All facts. Whether a state will be granted, entry is to be allowed or not. If entry is allowed today, tomorrow it can be struck out. That will remain state upon the facts, not disputed. That's fine. And he is not prejudiced. Whether my plot is recorded as for the industrial or for agricultural, Does he suffer any prejudice? Supreme Court has pointed out that any violation of the principle of natural justice, any illegality, irregularity will not furnish a cause of action unless there is an element of prejudice. What is the prejudice he is suffering? He is after my property. Is that a valid consideration, my lord? For moving this honorable court, my lord, and getting a stay or my lord, challenging the order of the tribunal. He is after my property. And all facts are before your lordship. Not for ascertaining. On the last occasion, he wanted to place the facts. Facts have been placed. Now, is it necessary, my lord? Your lordship will consider the facts, my lord. I thought there is no other conclusion possible. That I will get my property properly recorded. It is industrial, I will record it for industry. At present, it is recorded as agriculture. This is the dispute. Kindly consider the matter, my lord, from this aspect, and kindly consider, my lord, I don't know how many occasions your lordship moved a revisional application saying that all the facts are on the table, how the appeal court can remand the matter to the trial court instead of correcting the mistake committed to the trial court. Usual argument.
Mr. Mukherjee, you are trying to put a prejudice in us.
Well, is it unknown in the bar? I think, my lord, I am not trying to create a prejudice without any justification or traveling beyond the records. The commissioner has recorded this fact. Then what prompts him to raise an objection? How does he suffer? The commissioner, the dismissal of the appeal, I mean, that is on record. He has recorded it. These are the simple facts. We will kindly go. Your lordship judge will kindly go through it. On the earlier occasion, facts first, not on the record. That's why your lordship send it back on demand. Now all facts are on it. My lord, can your lordship hear me, my lord?
Yes, yes.
Kindly consider these facts.
No,
What is the prejudice to be suffered by them? My plot used for industrial purpose will be recorded for industry. He is coming to object to it. Nothing more.
Yes.
My lord, these are my submissions. No prejudice. All facts are there.
Judgment দুটো দেখাবেন?
কি?
Judgment দুটো দেখাবেন?
না, আমি judgment
reason?
আমি একটা judgment বলছি।
That I can see, but that nobody can dispute that proposition.
তাহলে আমি ঠিক কথা বলছি, বল।
What his argument is, two things. One is when the facts are already narrated, then in that event, even if the conclusion or there is some kind of a, the lacking in the reasons, then in that event, there is no fetter on the part of the appellate court, which has a powers under section 107, subsection 2 of the codicil procedure, that he can exercise all the powers that of the original court as well. So what Mr. Mukherjee is saying, that you can substitute, you can supply that particular reasons, and provided the ultimate conclusion is acceptable to the bench.
Exactly my argument last time. This was exactly my argument last time.
That is his contention. And what do you have to say about this?
That was Lordship sees page 632, the last order, where there was where it was heard for half an hour, 1 hour, facts fully narrated. It is my argument before last occasion that Lordship will kindly supply the reasons because the facts have been narrated, but as this time it was
No, the question, I understand.
In fact, that was my submission that, but the lordship said,
No, I tell you very frankly, what would happen? Suppose if this order goes rejection, then it has to go back.
it has to be, he has to give reason.
Correct. It has to go back. You are still not, there is no interim order which was there.
That was my prayer, my lord. The lordship
True. There
continue
was
the
no
interim
interim order.
order.
There was no interim order there. So it will again be reheard by the bench.
Yes.
Before whom the matter is referred. So subject to what? We will definitely decide that what is required to be done. I tell you very frankly, I may have argued many things. Everybody has argued many things while on that side of the room. It quite happened to me as well. Mr. Mukherjee was also instrumental in one of the matters. And this was first argued by me when I was on that side regarding this 14(3)(c)
I know.
of the Specific Relief Act.
Yes.
So I just said that the developer is not entitled to maintain a suit, nor he can seek an injunction. Mr. Mukherjee thereafter, that was first judgment was AIR 2005 Calcutta. Then came the Vipin Bhimani, Mr. Mukherjee argues, on the same line and a tune that it can't. Developer cannot maintain a suit, nor can seek an injunction.
That was accepted with the division bench.
No. Then that was a division bench. So
Yes, division.
when I depart from that side to this side,
also argued a matter opposite. I remember order 7 to 11.
when I depart from this side, then that judgment was cited, both argued by me in support of 14(3)(c). Mr. Mukherjee also argued in support of 14(3)(c). I said, now when I have come here, I have to be very clear. So I think, no, that principle should not apply. So I dissented.
Larger bench.
I dissented and referred the matter to a larger bench.
Ashok Jaiswal's case.
And then the matter went to the larger bench. 3-judge bench concurs with my dissenting view. Here, that yes, the developer can maintain a suit. There is no bar. This AIR 2005 Calcutta, which I argued against that, the SLP was preferred, which was also admitted by the Supreme Court. Later on in 2019 or 20, the Supreme Court upheld the contention of the special bench. That's my dissenting view as well was upheld. And it says, yes, the developer has a right. There is no difficulty. So that principle has gone. So definitely we will not go by a stricter way. If I depart from there to this side, there, I will definitely go by my own understanding. If I feel those principles are of an archaic time, should not by
Present understanding, not previous understanding.
Lordship missed out one thing here in this whole narration. Lordship also argued a case 14(3)(c) does not apply in Bhattacharya. I remember Lordship had argued just the opposite in another matter. I remember very clearly.
That was a privilege being there.
Conveniently forgetting it.
Yes.
Conveniently forgetting it.
Yes.
The contrary submission your lordship made.
So I remember that matter. In fact, Justice Bhattacharya then held my lord to my lord's.
This is up to you. We will definitely go by this, and we will have to find out whether there is any reason which could be discerned from this judgment.
Lordship.
First thing is, if we find that there is a reason may not be that extensive or elaborate.
Because
it is one thing to say that it is completely bereft of reasons, and it is another thing that there are scanty reasons, or the reasons are not that elaborate or adequate, which are required to be. In both the cases, first case, definitely my view as of today is that no, it should go back.
Lordship, one thing I want
and
to
the second one, my view is that there is no fetter on the part of the appellate court to make a elaborate reasons, provided the ultimate decision
has
is
to be after
correct.
hearing both sides. But the Lordship kindly sees page 648 once. 648.
So one has to find out it is absolutely bereft of reasons.
Lordship kindly sees 648.
647,
647, last 3 lines. 647, last 3 lines. last 3 lines of 647. The matter is remitted to the tribunal with the liberty to respond, number 1, to pray for interim order. And if such prayer is made, the tribunal shall decide the same after giving opportunity of hearing to the writ petitioner and the respondents therein by recording proper reasons in the light of the observations made above. Recording proper reasons. So, lordships on locus standi, lordship held that has to be decided finally. So, proper reasons. So, in this case, refusal also does not, whether it requires reasons or not, doesn't apply. Because lordship, when remanding it back, saying proper reasons. Is this proper reason? Lordship will say this is no improvement from last time. And when my argument was, this is not his property. This is vested property. This is under the Urban Land Ceiling Act, vested
You
property.
purchase the vested property.
Under Section 20, they took special permission.
I believe that matter went against you so far as the urban land ceiling
Rejected.
concept is
That's
concerned.
good application.
Well, yes.
So
Now
far as
that
urban, that has gone against you.
that is pending in the writ
Whatever, unless the judgment is set aside,
petition. Well,
the binding efficacy or the legal efficacy of the judgment is not
There's
effaced.
a catch there, Malu.
It is not effaced.
Well, there's a catch there. There it was. There it went against me because of 4C permission. There it was.
Whatever
4C permission is given, so my point is gone.
Mr. Mitro, whatever be the reason, the fact remains as on date that you could not succeed
because of
under
this.
the urban land ceiling proceedings. If I correctly remember, that goes against you. If you succeed in your the appeal or the writ petition, whatever you have taken out, or a tribunal, and the order of that is set aside, definitely you have a good case. But so long mere filing an appeal does not tantamount that the legal efficacy or a binding efficacy of the judgment is effaced, or it is to be ignored. No, you can't.
May I respond to this?
Can't. Law is very settled in this regard.
That is,
It is yet binding on the parties, so long it is set aside.
But there's an exception which applies in our case. There it was allowed, there it was dismissed because of Section 4C permission is granted. That was the reason why I lost there.
Correct.
So now if
by it's not the advisory jurisdiction we should exercise. If there is a change circumstances or if there is a subsequent events that has happened, what is the course which you should adopt in this regard.
At that time,
here, this is not related to urban ceiling. You can't now say that so far as a permission or there is a bar, there is an embargo, it comes within the mischief, because that order still stares at your face unless set aside.
But that may be so. But this is still section toward the urban vested land. And for the vested land, the procedure under 4C is much more elaborate, which was not followed here.
No. Again,
that was
what he says is he wanted to just try to dilute the entire the gamut of the thing in that sense, though it is under 4C. In fact, it is really an application for correction of the entry in the record of rights. This is what he really, Mr. Mukherjee, wanted to say. It's a correction of an entry in the record of rights. So what he says, the purpose is, according to him, maybe it is recorded as a Sali land.
Change of user.
But it was all along intended or actually used for industrial purposes. Even your land, which was a part of this land, the entire land, and recorded as a Sali, as I believe at the time of sale must have been recorded as a Sali.
Yes.
It's also been used by you for industrial purposes. So in that event, it is what he says is, I do not know, subsequently you got it changed or subsequently you did not get it changed. I do not know. That's neither here. I do not know. I have not read that. Maybe for whatever reasons. So this remained. Now, injunction is to what extent? You wanted an injunction against the 4C proceeding. That you stayed the 4C proceeding.
No, 4C order should be stayed. 4C order should be stayed. What was the
Only correction.
654 appeal. And so far this earlier.
Secondly, 4C proceeding has come to an end.
come to an end.
And
Appeal
you
was filed.
challenged, yeah, appeal is filed,
Section 54 appeal was filed.
correct. 54 appeal is pending.
54 appeal, there was interim order passed, not to give effect, status quo maintained. 54 appeal, when it got dismissed, we came up in LRT.
Oh, that means you lost in the appeal also as well.
This is the continuation
Now,
of
now
that.
you approach the tribunal. Before the tribunal, you wanted that this interim order which was there, operative in the appellate forum, should also be restored. Or may I use the term the resurrected or reimposed? This is you wanted, and that has been found against you.
That was held in my favor. So it was continued. Then Lordship, they filed a 227 or 286, whatever, appeal to my Lord's tribunal, to my Lord's court, where it was, they took the point of locus standi. Locus standi, Lordship categorically held that this did not hold against me. It was argued at length. Well, I had shown that this submission, that this is a change of user, is a new case. You cannot argue in the appeal stage. Super appeal. This is really a super appeal stage. And number two, there is still change of user because it was industrial. And now it's industrial, I do not mind. So that is the change of user. But industrial now to industrial park, that's wholly different. That is for commercial development with the promoter, go downs, etc. Because industry, I have no difficulty. But if it is not industry, then under the scheme of the state government, vested land, if somebody wants to change the user, then it should be made
Wasted land?
under the Urban Land Ceiling Act. That remains so.
That you can't say so.
Well, it is still vested. It is section 20.
Sir, the question, you do not know whether there is a ceiling. Urban land ceiling does not talk about that. If somebody has a property more than a ceiling area,
automatically vests?
No. I do not know under the Urban Land Ceiling Act.
Automatic
whether automatic.
Automatic vesting.
I
A proceeding is required.
have a different notion.
The procedure from the draft statement, final statement has to be filed.
These are all under the State Acquisition Act when the act came in 1953, if I believe. Urban land ceiling, I do not know whether.
Because the vesting takes effect from the
Vesting,
coming of that.
I have a doubt.
Vesting takes effect from the date of coming of that.
Show us the law. I may be wrong. I tell you very frankly, I have no idea. Please correct me. Please correct me from the provision of the Urban Land Ceiling Act, whether it contemplates vesting under the West Bengal State Acquisition Act 1953. I can understand.
But there also selection of land is there, procedure is there.
No procedure.
So where which
wasted means wasted.
Which part is retained? Which part is
that
retained?
is subsequently under section 5 capital A.
Yes.
Retention.
Section
Under
6.
6.
6A to J.
Yes.
But then it becomes a freehold land under section 4 of the Land Reforms Act. What you retain becomes your freehold land, so no longer vested under section 4.
So that
as
is,
amended.
that is by operation of that act. Does
Yes, by
not come under
Land
the
Reforms
operation of
Act.
the State Acquisition Act. Does not come under the
The state government has rejected its contention.
No, আমার মনে নয়. I may be wrong. আমার actually জানাও নেই.
Because
বড় post হয়ে কথা বলতে পারবো না, but
because here there is only because there was vesting, there was an exemption given for under section 20 for them to use it for industrial purpose. So, and that too only for manufacturing certain type of goods. That is section 20 exemption. Welding. So there I said when they are changing the nature of use, that exemption should be automatically withdrawn. To that, the answer was, I've got permission under section 4C to convert. That's when we came here and we got the order from the High Court that you may go and challenge. And we challenged, but we lost. LRT section 54 appeal. It is, and this is petty. So this is not ordinary that I am interested in my neighbor's land being vested. Though there is provision that a neighbor can object under section 4C. in the land reform manual, there is provision that neighbors' objections will be invited and considered.
Then another question to consider whether the land reforms manual is an enforceable statutory document, legally enforceable document.
That's something I would not
If
know.
it is not a legally enforceable document, can you take advantage of that?
So Mukherjee is taking that. Rule 166 is that the section 4C has no provision for change of user different class. It is rule 166 of the West Bengal land reform manual which has that.
I don't think so. There is one judgment of our High Court which says land reforms manual has no
Statutory
legal
force.
is not a statutory document.
But then change of user is no separate category.
That is under the substantive law that is there. Manual is the guidelines in that sense, the how the authorities would proceed. That's the another. That has been held by Justice, if I correctly remember, Justice Shubhra Kumar Mukherjee, that it is not a legally enforceable document. It's not a statutory document.
I can remember. On ferry ghat matter, this was it.
But Lordship, I have got all the judgments delivered by, of course, Supreme Court and my lord and Asha Jashubhra Kumar Mukherjee division bench where no reasons it should be judged.
So that is what
parroting the
Mr.
sections
Mukherjee,
that-
Mr. Mukherjee, sorry, Mr. Mitro, I must be very clear. If I find, I tell you very frankly, if I find that there is no reason at all, it's complete breadth of the reasons. Definitely prima facie, nowadays I am not using the word tentative. Prima facie, I am of the view that certainly this needs interference and cannot. But if there is a scanty reason or a little bit reasons, not that elaborate which the court expects that
my lord's order says proper reasons. My lord's earlier remand order.
then in that event, there is no fetter on the part of the appellate court to substitute or to supplement that particular.
But then Lordship has to be heard.
That's
Then we
why
have
I'm
to be
saying
heard.
there are two reasons. If you say bereft, I tell you prima facie, I am with you. I am with you.
And I've got all those judgments where
we will
are
remit it back to the, we'll remit it to the tribunal to rehear the
As per my lord's earlier order, Lordship earlier order says with proper reasons.
No, proper reasons have to be interpreted in that way.
The proper reasons, proper reasons. That's very
Have
common
you
English
read, have
language.
you read my judgment 3 days before?
Well, we know all the judgments of my lord on these reasons, which are.
Have you read my judgment just delivered yesterday?
That division.
Yes. Hey. এই একটা কালকে দিলাম জাজমেন্ট একটা বড় দেখি হ্যাঁ 16th, is it here?
Cost settle देखिए, cost settle.
I have indicated for this reason.
Cost settle the
This is below the belt. Well, this is below the belt. This
No,
is
no,
below
that's
the
my
belt.
view. I have already taken. I have just day before yesterday.
Something we don't know. We
No,
cannot
that's
know.
why I'm just asking him if the copy is here. Must be on the server. If the copy is here, then there's no difficulty.
On what point, Ballard? On the point of?
I think everybody will be eager to read that 2.5 pages. So Mukherjee, I do not know whether I am correct or not, but rather we have.
Yes, my lord.
May I read it?
It's always a pleasure listening to reading some of my lord's judgment.
I have said that on the conspectus of the aforesaid submission, let us decide whether the impugned order can be justified or needs interference. Recently, Then I started. A trend is developed in the bar in interpreting the words used in a common parlance in most different manner to inculcate a sense that the finding arrived by the court in judicial dispensation suffers from several infirmities and reflects the mind of a judge in hindsight, which in our opinion does not reveal so. The words or expressions are segregated and projected in such a manner that the entire decision-making process is vitiated, and the order cannot stand on a well-established principle of law. The words of insignificance is attempted to project the words or expressions of vital importance in a process with the rhetoric of the reasonings, which does not appear to be of any significant value. The words or expression divorced from the context should not be permitted to be agitated. Every word so used have to be understood in juxtaposition with the context in which it is used and cannot be allowed to assign a different meaning, treating the same as a standalone words or expressions carrying a meaning which impinges the process of reasoning in the orders or the judgments. Every word is capable of more than one meaning given in the dictionary, and it is an ardent duty of the court to find out its meaning in the perspective of the context in which it is used and not to assign a meaning perceived by an aggrieved litigant. The words or expression which are commonly used having no bearing in adjudication of a dispute, but merely an expression under the common parlance, should not be permitted to interpret differently, having no bearing on a core issue. In the instant case, that was the case, the expression, if any, in relation to a reply filed by the party is critically examined by the learned counsel for the appellant, in the sense that the learned judge in the court below was skeptical whether such reply are filed or taken on record. The aforesaid expression is sought to be interpreted as, according to the counsel for the appellant, gives an impression that the learned judge was not sure whether such reply is on record, or even if such a reply is on record, may not have read it. The impugned order would reveal that the pleadings of the parties in relation to a temporary injunction, the opposition, and the reply has been succinctly jotted down therein, which by no stretch of imagination may inculcate a sense in the appellant that either the judge is not aware of such reply is on record, nor the same has been read. The aforesaid expression cannot be permitted to be divorced from the context and or the tenet of the order, more particularly when it can be reasonably ascertained therefrom that the same has been taken note of and the crux of the pleading and reply is narrated extensively. The argument should be restricted to a point involved in the proceeding emanating from the facts and law, and it is not appreciated that the arguments are advanced using the interpretative process having no bearing thereupon. Often the court faces a criticism from the bar that an ample opportunity to argue the matter has not been given, yet it is a corresponding duty of the bar to restrict the argument on the facts and law applicable in relation to a dispute and should not unnecessarily invest the time on an inconsequential and insignificant points, more particularly on the words or expression of common use as of seminal importance. It admits no ambiguity that the language used in the judgment rendered by the courts are not ordinarily read as a statute. The words or expression used in the statute carries an intention of the legislature, its purpose and the object and the relevant in the subject for which it is enacted. The aforesaid observations have been made, though not relevant, but for the purpose of imparting a sense of responsibility amongst the members of the bar to restrict the argument on the issues involved in the proceeding and assist the court in arriving at the decision so that it can achieve the very object of avoiding the wastage of time in addressing such insignificant thing. I do not know whether I am wrong or correct.
For this case, I bow down.
I do not know whether I am correct or wrong.
Sometimes it is wrong, sometimes it is right, depending upon the convenience.
Which only Mr. Mukherjee can say to a judge. Nobody else can afford to say that to a judge. But so, Lordship, can you see in what context Lordship said proper reason? Same situation, arguments noted, then the order, Lordship said give proper reason.
In that case, the word if any, the learned judge said that we have considered the applications, the rejoinders, and the reply, if any, filed. And then he proceeded and jotted down the application, the statements of the facts in the application, then opposition, and also reply. If any word was interpreted, that means either the judge was not sure that the reply is on record, nor he has read it. and 2 days on the expression if any was consumed. So we was compelled and prompted to make such
Right.
observations.
But that's very much required. But those are things which we don't find anywhere. The basic principles, we don't get those judgments. That's why.
So what do you want?
So Lordship, in case Lordship,
There are two options. You can please satisfy us. If it is a complete bereft of the reasons, set aside.
it is my submission.
That's you then continue at 2 and just tell us.
Of course, right.
No, this is not the case. Sorry. This can't be.
My lord, your lordship is sitting in other benches also.
No, Mr. Mukherjee, I tell you very frankly that so far as the other benches are concerned, it will not take 1 minute or 2 minutes.
I was apprehensive about that.
Special bench, we are sitting at 2 just to deliver a judgment. That will only take 1 minute time. The another bench, I believe the matter would not be taken up by us.
Okay, I was only thinking about that.
So we have to sit again.
So maybe come back after 3 p.m. because then I have a matter at 2:30. I'll do that and come back in case.
Come at 3.
I'm grateful.
No difficulty.
Mr. Mukherjee has said anything. He's in difficulty. He's what he
No,
has.
no, I am always available.
At 2, he has a difficulty. He says he want to come at 3. It's no difficulty.
Great. Thank you.
Read that. I do not know whether I am correct or wrong.
That's something I will keep for record because
Answer can be given in court. Deepak Ghosh का जान लीजिए.
वो दीपक घोष का है. बोलो. Yes.
Not sitting হয়.
যদি তো তাহলে তো আছে. হ্যাঁ হ্যাঁ
Arjun?
আরে ওটা সরাতে হবে না। না না ওটা বসেছে বসেছে। Call the Yes, the reference is answered as follows. In case of an affirmation of an order of the single bench passed in exercise of the original jurisdiction, either in the original site or the appellate site, the contempt would lie before the single bench, alleging the violation of the direction of the order passed by him. In case of reversal, modification, and setting aside the order of the single bench in an appeal under clause 15 of the latest patent by the division bench, the contempt would lie before the judges constituting a division bench who passed the order. 3. In the event an undertaking is given by a party to the proceeding before the single bench to do or not to do a certain thing, and challenge to an order could not yield in reversal or the modification of the original order, the contempt would lie to a judge before whom such undertaking was given. Then we have said that let the contempt application be listed before the respective bench in view of the reference being answered.
I am grateful, man.
Most grateful.
Oh, what a issue. Let's call the matter.
The Honorable Supreme Court on 28th April, my lord, was pleased to adjourn the matter till the 14th my lord, of July.
You're for the state.
Yes. My lord, I am for the petitioner, my lord. Item number 1.
So we are fixing this matter in the first week of August.
My lord.
Now
Grateful.
you'll have to take steps because my brother will not be there. Now the next bench has to be constituted.
My lord.
We don't know. So, yes. The councils appearing for the respective parties informed us that the special petition pending before the Supreme Court of India has been fixed on 14/7/2023.
Let the server copy of an order dated 28/4/2023 be kept on record. In view of the above, let this matter be listed in the first week of August 2023. Both the councils, all the councils appearing for the respective parties shall disclose the bench as to whether disclose the bench as to the fate of the special petition
I'm great.
on the written.
Grateful, Your Lordship. Great. Thanks.
All matters are adjourned.
Lordship passed an order on 13th of May, directing us to comply certain directions to inform our, but Your Lordship passed an order on 13th of May, directing us to comply with my Lord's order by 30th of May. Yes, till today morning, I've tried my level best to get the copy of the order so that I can commit it to the department.
It is already there.
No, whatever,
I think the
server is
server
not.
is not working.
Yeah,
The order is there. You can peruse the order and you can send it. What is
no,
the
but
difficulty?
the department wants the copy so that we can comment it about 100%.
We have the copy here. You can just take down and then gist of the order by your letter. You can communicate. Where is the difficulty? Just think about those days when there was no server or something. How we used to communicate the order. You can do it.
No, only but because
depend upon the technology all the time.
now the secretary that said that so we shall have to implement the order.
Sir, the order was dictated in the open court, sir.
Yes.
You know what is the text of the order or what is the tenet of the order. If you want, you can have a perusal. It's a public document now. You can peruse it. There's
May
no
I be
difficulty.
allowed to plain copy of the order so that immediately we can.
We can't give you in that fashion because now the order is signed, everything is done. Then we can't do that.
Or a register.
And there is an administrative order also of the Chief Justice that please do not give these plain copies. Very rarely we give.
That's a difficulty.
The difficulty is because the undertaking is taken from the lawyer and they do not honor the undertaking.
No,
That I will apply a certified copy and will get the certified copy. They applied, it lapses, they never obtain the certificate.
My Lord's order has to be communicated about
we can't
100
do that.
candidates. 100% has to be communicated along with my Lord's order.
You take down the text of it, what can be done, communicate it. That's the easy way of doing it. Expedite the matter. Don't go by these technicalities. You can peruse the order. There is no difficulty. You can communicate it. Yes.
My lord, we have, my lord, made the supplementary affidavit ready, my lord. ये देखिए तो क्या चीज
Yes.
There is a delay of 71 days, my lord.
The erstwhile advocate and record has come. He said within half an hour.
No, my lord, he has gone back to hospital. Mother is hospitalized, my lord. Mother is hospitalized, my lord.
No, that you said. Then you said that he said that he will
we have
come in.
communicated, asked him to, my lord, come, but my lord, I think, my lord, he has again gone back, my lord, to the, my lord.
This is an application for condonation of delay in filing the instant appeal beyond the statutory it's provided therefore. There is a delay of 71 days in preferring the instant appeal. Stop. It is
page 6 will not pray.
It is stated in the said application that the order dated December 5, 2022 was not communicated to the petitioner by the erstwhile learned advocate, advocate on record. And after coming to know of the said order, the petitioner contacted the said learned advocate on record, but because of the Christmas vacation, adequate steps could not be taken. However, there was certain aspersions made against the erstwhile advocate on record, which we noticed on the last occasion and invited the attention of the learned advocate appearing for the petitioner in this regard. Today, the supplementary affidavit is filed by the appellant petitioner.
to withdraw the aspersions made in paragraph 5 of the said application, as it was unwarranted. Be that as it may, we find that if there is any lapses or the latches on the part of the advocate on record, the same should not stand in the way of deciding the appeal on its merit. Though we do not intend to go into the veracity of such aspersions, which is later on withdrawn, as the court would encourage the litigation to be decided on merit, rather than to nip in the bud on the anvil of limitation. This court finds that the cause shown in the application is sufficient enough to exercise the discretion of condonation of delay. Accordingly, the application is allowed. Delay in filing the appeal is hereby condoned. Let the application for stay be listed 1 week after the reopening of this court following summer vacation.
I'm grateful, grateful, grateful.
Yes, call.
কি মানে একটা সিটে করিস নি আলাদা আলাদা ঠিক আছে দশ সাহেবদের কই দেওয়া আছে
Yes, sir.
My lord, pursuant to your lordship's direction, my lord, in a tabulated form, we have published the points, my lord, in respect of the 10C, my lord, it's different now, my lord, in respect of the scheme, rationalization scheme. My lord, kindly take up the tabulation form. First relates to WPA 10271 of.
Why this paper is appearing here? In the file? What is this?
I'm sorry, my lord.
These two papers are there in the file.
This is not
old matter is
old matter. Well, I think this doesn't relate to the. Yes.
Must have been given, otherwise how it will appear? It will be there on
Part of the
record.
petition or nothing, nothing.
So,
देखिए तो
आगे देखो.
not related.
My officer told that that was given to the court and the court has kept in the file.
Must be. I also believe must be because I tell you lordship, this colored one, all kinds of teachers transfer are stopped until further order.
I
So it
do not
must-
know. What is this?
I'm not also aware of, I'm sorry. This is one of the WP number
13628.
13628. No, one.
Robin to do.
2018 matter, your lordships. My lord,
Robin to do.
my lord, kindly take from my lord,
23 matters, my lord. এটা কত number? Serial number 16.
আগের দিন 16 order হয়েছে। My lord, these are the old matters.
এটা যশোরে দিয়ে দাও, records এ ছিল থাক।
That's, my lord, from item 15, my lord, are the 2023 matters.
রাখো ভিতরে।
But in the tabulated, in the tabulated CD, your losses will find the first one is item number 16 of today's list.
Item number 16 টা বার করো।
As a scheme.
Because certain matters are already covered by that particular undertaking. So
Yes,
you
sir.
need not have to.
Those are 18 matters.
Yes. So only thing is the subsequent matters. Let us see one after another.
এই এখানে স্কিমটা কই রেশনালাইজেশন স্কিমটা এক পেজ কত বল এটা তো আমি ডিল করিনি পেজটা বল রেশনালাইজেশন স্কিম এটা বল
Yes. First, we are taking up this
Sanchita Bhaumi.
Sanchita Bhaumi. Yes.
Namalat,
Yes,
you lost.
let us see, advocate. What is the view? What is the stand of the advocate general?
Is
My lord, I would, my lord, rely on 3 decisions, my lord, of the court. And my lord, then my lord, deal with my lord each one, because I want to show your lordships that my lord, the chart, my lord, which has been prepared is my lord, not a fair preparation of the chart. So on that ground itself, my lord, the petition should be, my lord, I'm not saying dismissal, there's ultra vires issue here, but my lord, there's no question of any interim relief.
Why you say not a fair preparation or a compilation?
Yes, my lord, kindly take the chart once. My lord.
No, we are having a chart before
Yes,
us.
my lord, kindly have a look at.
Sanchita Bhaumik.
Yes, my lord. Kindly take paragraph 26, my lord, of the petition.
So what do you say?
Now, your lordships, my lord, is suffering from serious gynecologic,
Yes.
should be gynecological disease and undergone operation, etc. Due to such serious disease, she is not able to discharge her duty after long distance journey. Petitioner has to look after her family, mainly old age mother, widowed mother, daughter. Due to such reason, she applied for transfer. Now, my lord, kindly come to, my lord, point 4.
She was transferred to a nearby school on that score.
My lord, Utsoshri, my lord, that's my lord on the portal.
No, that is what is there. Now she has been retransferred.
Rationalization. My lord, kindly come to
multiple
my lord,
five
the
words.
chart. My lord, kindly come to point 4.
এটাই
My lord, at the bottom, my lord, first page, bottom. Petitioner suffering from multiple fibroids in uterus and needs hysterectomy surgery, and thus transfer is violative of clause 2 of the rationalization scheme. So, my lord, there is, according to the petitioner, my lord, a need for, my lord, a surgery. Now, I'm showing your lordship para 26. Surgery has happened. Not only that, now kindly take the annexures, my lord. Kindly take the annexures, my lord, page 93.
93 call.
My lord, now, my lord, kindly see this. This is, my lord, a discharge summary, my lord, which has, my lord, happened.
9/4/2022.
Correct. My lord, it's happened.
The surgery is over. 9th of April 2022. This is a discharge summary. Now, my lord, kindly come to my lord surgery procedural details. Kindly have on that under discharge summary 7th field, 8th field. Total abdominal hysterectomy with so and so and so and so. Findings uterus bulky, multiple. This is my lord the finding my lord at the surgery.
Yes.
So, my lord, this, my lord, is, my lord, not, I am saying, my lord, not a fair representation. Now, my lord, the chart. Now, my lord, kindly have a look at, my lord, the daughter. My lord, this daughter is also a ground. Kindly have a look at page 99. That's the birth certificate of the daughter. My lord, 23rd September 2003. 19 plus years.
Yes.
I'm only saying not fair. What has happened? And my lord, I want to cite 3 cases that there is no question of, my lord, any interdict here, my lord, regarding, my lord, transfers. And I'll go, my lord, case by case after that. What has been, my lord, given to your lordship?
Before citing the judgment in regards facts and the tabulation sheet, in respect of at least this matter, may I make submissions, your lordships? Vis-a-vis the rationalization scheme.
No, we'll hear you.
All
We will hear you. Let him first place the law.
Yes.
What is the law on the subject?
Yes, my lord. Kindly have a look. First, my lord, at decision reported in 1993, 4 Supreme Court cases, 357. My lord, the argument here was, my lord, that transfer was not as per guidelines. My lord, I'll show everything as per guidelines. But my lord, I am now saying, my lord, first submission, my lord, mere violation of guidelines, my lord, is not good enough. Kindly come to paragraph 6. My lord, incident of services are applicable. My lord, argument, my lord. Now kindly come to placidum D, 2 lines after that. That the respondent is liable to transfer anywhere in India is not in dispute. Here we say any school, my lord, in the state of West Bengal. It is not the case of the respondent that the order of his transfer is vitiated by malefides on the part of the authority making the order. Though the tribunal does say so merely because certain guidelines issued by the central government are not followed, with which finding we shall deal later. The respondent attributed mischief to his immediate superior, who had nothing to do with his transfer. All he says is that he should not be transferred because his wife is working at Shillong, his children are studying there, and also because his health had suffered a setback some time ago. He relies upon certain executive instructions issued by the government in that behalf. Those instructions are in the nature of guidelines. They do not have statutory force. Then para 7. Who should be transferred where is a matter for the appropriate authority to decide. Unless the order of transfer is vitiated by malefides or is made in violation of any statutory provisions, the court cannot interfere with it. While ordering the transfer, there is no doubt the authority must keep in mind the guidelines issued by the government on the subject. Similarly, if a person makes any representation with respect to his transfer, the appropriate authority must consider the same having regard to the exigencies of administration. The guidelines say that as far as possible, husband and wife must be posted at the same place. The said guideline, however, does not confer upon the government employee a legally enforceable right. Now, my lord, I, my lord, rely, my lord, on these 2 paragraphs, my lord, for, my lord, advancing, my lord, 2 arguments before your lordships. My lord, to say, my lord, that their transfer, my lord, simply because it's contrary to a guideline, my lord, is bad, or my lord, malafide, my lord, will not do. It's not permissible. Second, my lord, we have a notification here, my lord, as the paragraph 7, which talks about a representation. My lord, if, my lord, somebody, my lord, has a problem, my lord, we have a notification here, my lord, of, my lord. What? What are you talking? My lord, of, my lord, 12th of March, 2018. My lord, kindly see, my lord, clause 7. My lord, no representation. None at all. My lord, first, my lord, no enforceable right. My lord, merely because violation of guidelines, my lord, there, my lord, cannot be, my lord, transfer cannot be struck down as malafide. And my lord, clause 7 of this, my lord, which everybody is aware of, my lord, no, my lord, representation, my lord, made. Now, my lord, I want to rely on, my lord, a high court judgment, my lord, of a division bench of our high court. My lord, it's an unreported judgment, 23rd of March, 2017. Which, MAT 1575 of 2016. Yeah. My lord, kindly take page 7, my lord. On hearing the learned counsel for the parties, we find that some of the teachers, being aggrieved by their order of transfer, had approached this court for interference under Article 226. It is not denied by them that their services are transferable, and it is not a right of an employee to choose his place of posting. Rather, it is the right of the management to place a teacher where his potential can be used to maximum. Such a teacher cannot challenge his order of transfer by the management until and unless he is able to prove the malafide and victimization on the face of the record, merely because, according to his interpretation, a guideline or a rule is alleged to have been violated, or he is in personal difficulty and does not want to join his transferred place of posting. He cannot come to writ jurisdiction, for he cannot choose his place of posting, and there is no such right vested in him otherwise than what we have observed above.
Two broader principles which has been laid
My lord,
down.
it's division bench. I'm before a division bench.
Supreme Court has said that there are a scope. It's not that the High Court cannot interfere, cannot interfere.
Saying that. I'm not.
Here is a too generalized and too broader proposition that under no circumstances he can come to the court.
I am.
That I.
My lord, we are at a discretionary stage now.
Absolutely.
Correct. So, my lord, I am just showing, my lord, what my lord has happened. No, my lord, I'll tell your lordship why this is important. My lord, we have, my lord, these transfer provisions. My lord, we have, my lord, a situation of Right to Education Act. We, my lord, also, my lord, as a state, my lord, particularly, my lord, after, my lord, Article 21A, and my lord, in 21 also education in any event was there. My lord, the prime stakeholder, my lord, is the student. Is the student, my lord. And my lord, here it's school. My lord, now, my lord, students in a school, my lord, if, my lord, there is a rationalization, and I can show to your lordships on the face of it, which I will do, my lord, that, my lord, from, my lord, excess teacher, my lord, ratio in the parent-teacher, my lord, staff pattern, my lord, it's going, my lord, to a deficit situation, my lord, that, my lord, is itself, my lord, rationalization. In fact, my lord, I'll tell your lordships here, my lord, this chart, other than 3 cases, Calcutta, which has a surfeit of teachers, my lord, the transfers are happening, my lord, to South 24 Parganas. On the basis of, and my lord, the priority given, my lord, is, my lord, the persons who've joined last, my lord, are junior, my lord, who are going out first. I have, my lord, all the documents, decision-making process, I have, my lord, everything here, which I will, my lord, hand up. Or, my lord, I can put on affidavit. But, my lord, I am showing your lordship this because, my lord, kindly come to page 7, last 3 lines. This is very important. A teacher belongs to, my lord, a teacher.
No, that is a noble profession.
Absolutely, my lord. Absolutely.
And
And, my lord,
their conduct must be above board.
kindly-
What is not expected from a normal behaved
Correct.
person,
Because they said
their
example,
conduct must be.
make
Always, we look up,
Correct.
in our young days, we look up at the teachers
My lord,
because
sir,
what they used to say is the summons.
Yes.
We say the summons for us.
Now, my lord, this is
Always, the teachers are always put.
now, my lord, kindly look at the age group, my lord, where, my lord, these transfers are happening. My lord,
There is a slok, Sanskrit slok, Guru Brahma, Guru Vishnu.
my lord, my lord, in my lord, every religion, my lord, every, my lord, social, my lord, order, my lord, teachers, my lord, the gurus, my lord, have to, my lord, command this respect. And, my lord, there's reason for it because they set example, an example by sacrifice. My lord, this is what your lordship's considering today. Unless, my lord, the mala fide, my lord, is established on the face of it, my lord, there is no question of, my lord, those cases your lordships would recall, my lord. My lord, in what background it happened? Your lordship looked at it and said, and I said very well, my lord, not stay on transfer, but no coercive steps so that there's no break in service. And many people joined, my lord, in spite of that, many have joined, my lord, apropos those transfer orders. Because the Supreme Court, my lord, when the Supreme Court heard the matter, many had joined already, some joined thereafter, but, my lord, some also didn't join and had the protection, my lord, of your lordship's order. But, my lord, here, my lord, we, my lord, have decided, my lord, to have, my lord, a policy of rationalization. And when I place the policy, your lordship will find it is to take care, my lord, of this huge imbalance. My lord, there's one public interest litigation also pending, where, my lord, right to education figures, my lord, were called for by court from every district, from every school. And, my lord, the court has also observed there, my lord, that we must have the first thing, my lord, which the, my lord, as far as schools are concerned, which has to be, my lord, addressed is the, my lord, imbalance, my lord, in parent-teacher ratio. Merely because, my lord, Kolkata happens to be, my lord, in, my lord, an urban section, my lord, doesn't mean, my lord, that the rural population, my lord, the rural children should get deprived. Everybody can't have Kolkata. My lord, this is, my lord, the rationalization which has happened. And your lordship will see from the chart, other than three, my lord, in this entire chart which has been handed up, all are from Kolkata to South Kolkata, to South 24 Parganas. And South 24 Parganas, I don't have to tell your lordships, my lord, it is, my lord, not the best in terms of communication, because it's a riverine, my lord, on the, my lord, mouth of the delta. So, my lord, people find it difficult to travel from there. People find it difficult to travel there. But, my lord, children there can't be deprived. Nobody wants to go. I am this age. I have a minor child. I cannot go. My lord, first priority, my lord, is to ensure, my lord, that, my lord, the surplus, my lord, is, my lord, somebody who has surplus kindly give something to where there's a deficit. Those children have done no wrong. And that's, my lord, the rationalization here. And here, my lord, every teacher is espousing a cause of personal difficulty. Personal difficulty. And, my lord, I'm not saying, my lord, a policy, guideline, etc. is cast in stone. It's not. My lord, it's just been introduced. There can be teething problems. But, my lord, that does not mean, my lord, that, my lord, young children, my lord, should be, my lord, deprived. My lord, then, my lord, if this is the position, my lord, there's one interdict now. Kindly see, my lord, the far-reaching consequence. My lord, yesterday, the learned single judge took up some matters. My lord, they've been kept, my lord, after the vacation on the 16th. Affidavit directions, no stay. My lord, vis-a-vis transfer. Similar kind of grievances, but, my lord, I said, naturally, I'm not saying that's binding or whatever. I'm on, my lord, I'm willing to address this issue before your lordship, that, my lord, there's no case made out, my lord, of, my lord, malafide on the face of it. That's the test. Merely using malafide, you've not followed guidelines. No, that will not do. And my lord, the state made a mistake. My lord, I'm saying so, my lord, because my lord, courts noticed, because courts have noticed that Utsoshri was misused. There were many votaries for it when it started initially. My lord, in fact, my lord, my argument before your lordships was transfer by the state or at the behest of the state was always an incident of service, because this court has treated, my lord, employment of teachers as, my lord, public employment. My lord, 10A and 10B, my lord, came in because teachers, my lord, were also required to be valued. Their interests were recognized. So one was a case of mutual transfer. The other was, my lord, a portal, my lord, opening up twice a year. So that, my lord, but what happened was the discretion given there, my lord, resulted in, my lord, postings, my lord, being done through, my lord, transfers happening through the portal, which resulted in, my lord, the, my lord, pupil-teacher ratio, my lord, getting completely skewed. Everybody wanted to come to Kolkata. Everybody would like to be in Siliguri, who are from that end. My lord, urban, semi-urban, my lord, is what, my lord, is the first choice. And then, my lord, what happens in, my lord, rural areas, backward areas, my lord, nobody will want to go there. So, my lord, my lord, the state.
Tell me, I do not know. I have not gone into that particular provision of 10A or 10B or a 10C, because we have not really actually applied our mind on that, because the matter is at the very nebulous stage at this, we can say. What we are asking you, is there any provisions there that you have given them a right to apply for mutual transfer by 10A, as I understood from it? You have given them a right to apply under 10B, where you can think of transferring somewhere. 10B is is relation to
my lord,
Uttosri.
My lord, in 10B, in aid of 10B, my lord.
No, I'm asking you. There. And the 10C is also, the right has been given you
to the my lord, state
to transfer.
Yes.
Now, is it mandatory under the FSA provisions that the moment an application for transfer is made, the state is bound to decide or bound to accept this and cannot reject that application?
My lord, may I put it? My lord, mutual transfer, my lord, there is no displacement.
No,
my lord, in the teacher.
Sometimes it so happened you think that mutual transfer may create some problems. It may so happen that for particular teacher in the school, excellent, and all the students, they want that teacher to be there because of the way she teaches or he teaches and the knowledge which he has acquired. There are many things, and he or she may opt for mutual. There may be some kind of a resistance that may come from that school. I'm just asking whether in case of such nature, whether there is any discretion or any right which is vested upon the state or any authorities to say that even a mutual, we are not going to accept it.
My lord, may I put it this way? If there is a representation, my lord, made, which can show, my lord, that, my lord, education will suffer overall, because your lordships might remember, my lord, I was slightly older than your lordships, my lord, so I'll indicate.
Not slightly.
my lord, I might look younger, my lord. But my lord, may I, my lord, indicate one thing? My lord, in university, my lord, where, my lord, one has, my lord, a first-hand, my lord, experience. We agitated as students because, my lord, the college we went to, my lord, was, my lord, a college which had the highest admission standards. My lord, unless you were a particular percentage and you qualified in a competitive examination held by the college itself, you would not get into, say, economics at 40 seats, statistics at 30 seats, physics at 50 seats. You would not get in. So, my lord, what happened then was, you got students, not necessarily the best, but we got students who had achieved high academically and they had passed this internal examination and got it. Then, my lord, the state said, and those days, my lord, it was the left front. My lord, they said we cannot have elitism in education. So therefore, the professor who was head of the department in economics, Professor Deepak Banerjee, needs to be transferred. My lord, representations were made. People, my lord, realized, my lord, that the students here have, through a yardstick, shown that they deserve the better education, the best who are in the education field. But my lord, schools, we are starting at a much lower level. My lord, the first competitive examination, my lord, is happening, my lord. Earlier it was 10, now 10 has become, my lord, internal basically, so it's just 12. And previously it used to be just 11. And my lord,
In our days, even a class 4,
yes. No, those tests are internal tests still, my lord.
not board,
Oh, board, correct. Too.
class
Yes,
4.
yes. Which, my lord, explains, my lord, why your lordships, my lord, retain more.
Nowadays, nobody
Nothing, no
remembers this
examinations till
young
class
lords, they do
Yeah.
not remember.
So,
Even
my lord, all that I'm
class 4,
saying,
there was a board.
all that I'm saying, my lord, is, my lord, really, my lord, the elitism, my lord, is, my lord, the last.
But only thing is, Mr. Advocate General, apart from this, because there is one issue which has evolved or which has come up relating to that particular, the virus of section 10C. That issue is yet to be decided. If those transfers appears to be in violation of any of this particular provision of 10C, or rather, I would not say that. Suppose if the 10C, there are two situations that may come ultimately. Either holding the 10C is intravirus or the 10C is ultravirus. Suppose the second latter situation, the ultravirus.
Yes, then your lordships have to
Then-
decide further.
Then,
My lord, it
then
is
the
also-
question would be that what would happen?
Yes, now, my lord, may I put it this way? Your lordships, my lord, then your lordships have to take a step further if it's the second. Your lordships then have to hold that, my lord, transfer is also not an incident of service. And your lordship,
That we can't, because that is too settled a proposition.
yes, now, my lord,
Even
that-
if they
yes,
cannot come in the way and argue that it is not an incident
correct.
of
Now, my lord,
service.
now, my lord,
It is
so-
an
so, my
incident
lord,
of service.
so
Nobody
my
can
lord,
dispute
yes,
it.
So, my lord, if your lordships, my lord, proceed on the basis that, my lord, transfer, my lord, is an incident of service, then, my lord, forget the guidelines. My lord, guidelines are bad, provision is bad, then, my lord, as is, my lord, are they, my lord, liable to be transferred or not? My lord, if they are, it's a very high ask, my lord, for them, my lord, to show that it's, my lord, malafide. Because unless, my lord, your lordships hold, my lord, that transfer, because your lordships recall, my lord, that Supreme Court interim order as well, my lord, learned single judge passed an interim order. My lord, allowed it. My lord, that went up, my lord, on appeal. Appeal vacated it. Matter went to the Supreme Court, specially petition, specifically the order says you go and join. And then when the hearing, my lord, started before your lordships, my lord, there was no interim order. My lord, what happened? My lord, vacation was interfering. My lord.
Now it is again interfering.
No, but my lord, my lord, they had started addressing.
It's also closed now.
My lord, they had, my lord, started interfering. My lord, having difficulty. 2 adjournments were taken before your lordship. And then
That is why we were suggesting
can't-
that
my lord, we have a-
early date, so that we can dispose of the matter finally. But the difficulty is all the councils, they are not agreeable.
No, I'm agree with Mal. I have agreed to the Saturday as
No,
Mr.
no.
Advocate General also.
Before 24th.
I am agreeable. I am agreeable to do it.
Nobody is interested.
My learned senior
Well,
friend
I
has
have-
come in.
The schools are closed till when?
Like 10th we can subject to my learned 10th.
Until further order, morning. Until further.
my lord, there is,
What are you talking? Holidays, the schools are closed until further order. What are you talking?
my lord,
No, this can't be.
my lord, I'll tell your lordship, my lord,
What are you talking?
my lord, I'll tell your lordship what had happened. My lord, generally, my lord, it's the month of, my lord, My lord, after middle of June that they reopened. My lord, what happened was, my lord, there was, my lord, holiday given earlier. No, schools shut down earlier because of the heat wave. So, my lord, as of now, my lord, no order, my lord, has been communicated saying exactly when it is reopening. My lord, that's what it is.
No, I can understand the holiday has begun earlier. But so far as the reopening of the after the holiday, that would remain
That
static.
date will be
That
indicated.
remains static.
I'm sure it will be indicated shortly, my lord, but it's not
That
there.
is a static one that you have not. You have preponed. I would not say preponed the vacation, but you have given a more vacation. It
And we
starts
said
from
classes-
an earlier point of
and
time.
my lord,
That's
the
the difference.
notification says classes have to be made up as well. So, my lord, that will also happen.
Made up means you are creating more pressure on the stakeholder.
They are happy, my lord.
Is really putting a pressure or putting them in stress. How they will make up? They will make up either by extending the hours or reopening or opening the school on a holidays as well. How they will
My lord, courses also have to be finished, my lord.
Health. True, but these are the things which should be taken care of. That's putting a extra pressure on the student. The teachers may not, but they have now grown up. They can. But what about the tender children?
My lord, your lordship, my lord, sat for a class 4 board exam. Then your lordship didn't complain.
No. That time you don't realize anything.
My lord, schools are, my lord, also to have school. My lord, is also good for the children.
I think if all of you agree, we can, Mr. Advocate General, because we can fix this matter and we can finish it off.
My lord, the same thing happened last time.
No,
My
no.
lord, where, my lord,
When
time was taken.
because now the schools are closed. There is no question for the time being.
My lord, I want to
But
know.
now if it is up to normally that what was the the calendar when all these schools used to reopen. Suppose if there is no heat wave or something of that kind. What is the normal date of reopening of all the schools?
14th of
June. So it's up to 14 we can expect that at least. So can we take up the matter before 14?
Before?
14.
Before 14th, yes. My lord, on a weekday then. Yes.
Anytime. Let us, for the sake of the children,
Yes.
let us.
Yes.
And you know that
My lord, I just want
I
to
am
make-
also a part of one
Yes, yes.
committee where I really takes care of those children.
Yes. Now, my lord, may I make one thing very clear? Everybody knows here that for personal reasons, I will not be back in court till the 12th.
Yes.
I have had 2 bereavements in the family in 1 year. I have, my lord, some work to do. So, my lord, I have to, my lord, I'm not back in the High Court till the 13th. Your lordship keeps it on the 13th, 14th, 15th. Kindly don't, because one matter, my lord, has been fixed. My lord,
So can we fix it on 13 and 14, 2 days? These are the Tuesdays and Tuesday and Wednesday. I think all of you.
Certainly.
Then at least we can dispose of the matter on that day.
Lord, we
2
can,
days, I think.
Lord, we can continue even after court hour, normal court hours. I'm agreeable to do that. Do that. We have done already in other matters in courtroom number 11.
What
Do
is
that.
13 and 14?
Yes, certainly.
my lord, kindly keep it in the afternoon session so that we can go on till 7 or 8, my lord, whatever it is.
We are ready. We are agreeable.
And my lord,
Flies is not sparing me.
My lord, I don't mind. My lord, a hearing till midnight. I have no problem.
13 and 14?
Yes. But the matter has to finish. No adjournments from there.
No.
No, I will not. No adjournment.
No, my learned friend is not the only one. My lord, it should be clear that they will finish. My lord, on one day, I will finish the next day.
Straight. Now school is closed. We know for the time being what we have to do it. School is closed. There is no emergency situations. We will consider it and not to be taken as a precedence in that regard. And therefore, we want to dispose it of. But who has prepared this? Mr. Jana, you have to be very careful. If the first matter is like this, no. Factually, no. You had a problem, but you have projected the problem as if it is a recurring one. And definitely I was emotionally swayed by that. And even if he was opposing, I said, no, I will, because after looking at that, no human being would be able to say that you do not deserve some kind of a consideration. But this is not the way to project, Mr. Jana. No. You are first an officer of the court, you know. And second, you are representing your client. That's the second stage. You have to be very fair to the court when you prepare. You should be very careful. All the aforesaid matters have come. Please give those numbers to us, has come up by way of an assignment. As the vires of Section 10C of the West Bengal School Service Commission Act 1997, read with vires of Section T of this is under challenge. Slew of litigations have been filed by the respective writ petitioners. On being served with the order of transfer to the different school. Taking a plea not only of the constitutional validity of the aforesaid section, but also on other grounds, which according to them can never be recognized in a judicial dispensation. Some of the writ petitioners have taken a ground of they have taken a medical grounds. Some have taken a social compulsion. Some on personal reasons, which we think that the same would be decided at the latter stage of the proceedings. We do not intend to go into the veracity or the genuinity of such grounds having been assigned by each of the writ petitioners at this stage, as our consideration is squeezed to a virus of Section 10C of the said Act. So, we have been given to understand that in some of the matters, an undertaking was given by the learned Advocate General not to take any coercive, that the state would not take any coercive steps until the pendency of the instant writ petitions. But subsequently, a policy/guideline was introduced, which according to the learned Advocate General brings more clarity rationality and reasonability into the action of the state authorities in transferring the teacher from one school to another. On such score, this court directed to filter out those cases which have been filed after adoption of the guidelines in order to find out whether any interim protection is required to be extended to such writ petitioners. Today, the compilation of those cases were handed over to the court as well as to the Learned Advocate General, to which the Learned Advocate General submits that the same are not a fair compilation. Be that as it may, we find that the school is closed for summer vacation and expected to reopen on 14th of June 2023. However, it has been communicated to the court that the state has declared the vacations without specifying the date of its reopening by using the expression until within quote until further order. Since the schools are closed for vacation, we feel that it would subserve the justice if the writ petitions are taken up and finally disposed of by the bench during such vacation. Let these writ petitions be listed on 13th and 14th. Let it listed on 13th June 2023 as a specially fixed matter to be taken up at 10:30 a.m.
My lord, Lordship said after, my lord.
You said 12th, you have a problem, 13th
No,
and 14th?
12th, my lord, I am appearing and I'm landing in midnight. My lord, 13th, my lord, all that I'm saying, my lord, it's a PIL
14th.
day, my lord. So,
14th,
my lord,
no problem, 14th.
no, my lord, kindly keep it, my lord, kindly keep it 13th. All that I'm saying is kindly do it in the afternoon. And my lord, we'll go on, my lord. Let
We'll
it be
carry on,
understood,
we will
my
carry
lord,
on.
that they will finish on the 13th and I'll finish on the 14th.
13th at 2 p.m.
আরে সেটা তো শুরু কর
However, we made it clear that it is open to each of the writ petitioners
সেটাই তো বললো
if they feel so to join the school where they have been transferred.
My lord, there's no transfer order as yet.
only recommendation.
Only recommendation, my lord.
Now, we have been given to understand that till date the order of transfer has not been issued by the state, as the School Service Commission has issued the recommendation to an appropriate authority to take a follow-up action. Since the schools are closed for the vacation, and we have decided to dispose of the writ petitions, we feel that if any order of transfer is passed at this stage, it may invite some inconvenience We therefore feel that no coercive action should be taken by the state for the time being. However, it will not prevent each of the writ petitioners, in the event the order of transfer is issued by the authorities, to join the transferred school without prejudice to their rights and contentions in the notice. So, what more?
That finishes the policy. That finishes the policy. My lord, I thought, my lord, I'm willing to argue it today. My lord, kindly take it up, the entire matter today. I'm willing to argue it today. Today, tomorrow also, I'm willing to argue. Because this, my lord, kills the policy.
It will not. It will
No, it does. My lord, I worked on it. My lord, I'm telling your lordship, I worked on it to try and see, my lord, that there was no arbitrariness.
We have said, we have not said,
that's
I'm
fine.
telling you, Mr. Advocate General, we have said simply not the
My lord, there's
coercive.
already, my lord,
You have issued an order of transfer, which you can issue. If the order of transfer is issued, it is open to them to go and join. It's no difficult.
no, but your lordship said, my lord, no coercive steps.
Only thing is that do not take it. Do not take it. Do not take any coercive steps.
My lord,
Schools are closed. Kindly visualize.
my lord,
Schools,
they
they
failed
cannot go.
everywhere. My
If
lord,
they-
one bunch, my lord, has failed to get interim orders.
No, I understand. We are not saying so. We are not saying so. Only thing is coercive step because the schools are closed. That's the only way. But it does not stand in the way of issuance of the order of transfer. It will not stand.
I am only, my lord, submitting this. My lord, kindly keep, my lord, the interests of the children in mind.
That's why we have fixed it.
Nobody, my lord, even if one person goes after this order, my lord, my lord, I'm willing to have a wager with my learned friend, which is illegal. My lord, I'm willing to have that also. My lord, nobody will go because everybody is bothered about, my lord, what happens to them.
Why? Why? Who are you? Who are you to suggest? Who are you to suggest? It is not, I may be wrong, but my understanding is it is not obligatory on the part of them to frame a transfer policies. It's not obligatory. Where does it say that you'll have to frame a transfer policy? It is, if they have framed it, then they are bound by it. But it is not imperative that they are bound to frame. They can't. They may choose not to frame. But you can't say so. Why I say I just wanted to bring a rationale and the parity into it, because in some of the writ petitions, those the protections are being extended to them, and some, if they came later, that's why we wanted to give, nothing more than that, just to bring a parity. Though Mr. Advocate General is not very happy.
No, I'm not. I'm telling your lordship because I share that relationship with your lordship. I don't think, my lord, the court should enter into this arena unless your lordship's fine. That is absolutely.
But we will dispose of the matter. Don't worry. Before the school reopens, no difficulty. Because we find that at this stage, at least the students are not suffering for the time being. Because only thing is, when the school reopens, then they have to. But we have not stated anything. If you can do it. Whatever you want to do it, that's there. There is no stay order on this.
13 and 14.
Yes.
What?
Give that numbers. কি আছে ডাকো Yes, item number 1.
I beg to appear, my lord, on behalf of the respondent. My lord, I was praying, my lord, if it is not finished today, kindly don't take it up tomorrow, my lord, let it stand over till after vacation.
Yes,
My
state
lord,
of
if it is not finished today, your lordships are going to rise at 3:30.
Oh,
My lord, I'm praying for a short Passover, my lord.
this matter was continuing from the morning.
Yes, your lord.
She wanted after vacation.
Let it be after vacation, my lord, not tomorrow.
Yes.
Your lordship will hear it. Well, there's only the lordship will see whether there is any reason or not. Well, we've gone through properly. Your lordship will not find scanty reasons also. Scanty reasons also is not there. Bereft of reasons. What is there, my lord, your lordship, is this quoting of the provisions and, my lord, of reiteration of facts. That is what we've seen properly, my lord. Your lordship will check again, my lord.
Let us hear the matter. When?
Lordship will fix a date, my lord.
Immediately after reopening, we are fixing this matter. We'll hear it.
Lordship, kindly make it then parted at least. Otherwise, Lordship has heard for 2 days. Lordship has heard it. Again, starting anew, Lordship, please.
Don't apprehend.
I won't appear.
Don't apprehend.
Don't apprehend.
On 5th. On 5th.
Okay, ma'am.
Yes.
Make it 6th. If something happens, my lord,
What?
not on the first day, make it second.
Mukherjee is apprehending now.
No, I told don't apprehend.
All right, we will be there.
Yes. Let this matter be listed on 5th.
Sir, 6th
Under the heading motion to be taken up at 10:30 a.m. Come in the first half.
And
Yes.
may I wish my lord a very happy holiday. I don't think I have a matter tomorrow. So may I wish my lord a very happy holiday.
You are not here tomorrow.
I am here, but there are no briefs in my lord's court. So
Oh. Same to
so
you.
well, so kindly may I wish your lordship.
Permit me also, my lord, to join in wishing your lordship best of days.
Yes, I wish that you should keep good health, both mental, physical, both.
Just for 2 weeks. Then we are there to again start disturbing you.
Yes.
Grateful Lordship.
Yes. Oh, you want after vacation? Item number 8 after vacation. Yes. What is the, you just call out those matters. Item number 2, who is appearing?
I am appearing, my lord, for the petitioner, my lord.
Is there very urgent?
No, my lord.
After vacation? After vacation. 3. 3. Who is appearing in 3? Then 4. Who is for the 4? So anyhow, and then 6. 6 is gone. Huh? Seven.
Lordship, Kevin, I appear for the
That matter, Lordship will kindly remember. But
After vacation.
but after vacation, if it is, my lord, in that event, my lord, I am opposing. I do not want it after vacation because, my lord, I am being compelled right now, my lord, to go to Jabalpur right now. Yes, for which. No, what? My lord, this is that matter where, my lord, it is that matter, my lord, Lordship will